None appears to the petitioner. Dismissal, no prosecution.
Yes, sir, you can list item number 2.
No instruction, madam. Counsel, the petitioner states he has no instructions. Dismissal, no prosecution.
Item number 3.
None appears. Dismissal, no prosecution.
Item number 4.
None appears. Dismissal, no prosecution.
Item number 5.
May I please your lordship? I am in BC.
Yes.
May I please your lordship?
Yes.
The nodule land, the petitioner's family was in possession since 1922. In respect of a nodule land, the state authority previously conducted auction for settlement of the nodule land in respect of the person who is in possession. Accordingly, the petitioner became the highest bidder in the auction. He had deposited 1/10 of the total bid amount with the state government, but the balance amount they did not receive from us. On the contrary, they initiated a proceeding under the OPLE for eviction of the petitioners. Therefore, the petitioner approached this honorable court, and your lordship may kindly have a glance to the order I have quoted. The relevant portion is at page 5.
So you'll have to tell us. You'll have to tell us what has happened during the 18 years that this case has been pending here.
My lord, we are in possession of the land. They have granted a lease deed, but as per the statutory provisions, they have to settle with me with the status of royalty. I will take your lordship to the provisions of the act. Which
No, under what orders are you still continuing in possession, sir?
My lord, your lordship may kindly have a glance to the order passed by this honorable court. I have quoted the order at paragraph 6, page 3. This is the order passed on 16/10/2019 by the then Chief Justice B.L. Hansaria, Honorable Justice B.L. Hansaria, and I am taking to your lordship to paragraph 4 of the said judgment at page 5. Keeping in view the various order passed by the different authorities, we are of the opinion that interest of justice requires that in the fact and circumstances of the present case, the land should be settled with the petitioner on his paying a sum of rupees so and so, along with penalty of rupees so and so, as mentioned in the order dated 18/8/1971, for which we have already alluded. May it be stated here that the very initiation of the encroachment proceeding is untenable inasmuch as the land had been auctioned for settlement and the petitioner had purchased the same and had paid 1/10 of the bid money. No fault would be found with him. In the result, the petitioner is allowed the aforesaid direction, the amount in question be deposited within 2 months. I have deposited the amount. They have executed a lease deed under Annexure 1. Instead of making a lease deed, as per the provision of the statute, they should have settled the land with me with a royalty status. The relevant portion being Schedule 5.
Sir, what is the date of the registered lease deed?
Registered, it is of 1992.
Sir, the point is, if they did not comply with the order of this court, what was the remedy available to you?
My lord, they have complied. In place of settlement with royalty, they have issued a lease deed. They have partly complied.
Sir, let us be clear. Let us be clear.
My lord.
By issuing a lease deed instead of settlement, according to you, that is compliance?
No, it has not fully complied with the order.
1 minute. So what is the remedy if they have not complied?
My lord, in fact, the order was passed in 1990.
Sir, please answer the question. Please answer the question.
My lord, oblige, I know that.
Either you say, no, sir, I'm not unhappy at all. I'm very happy. They have a registered lease deed in my favor. I have nothing more to ask for. Suppose you say that, we'll close the case. Suppose you say, no, sir, they were supposed to settle the land in my favor, but they issued only a registered lease deed, which means you're not happy with what they have done, correct?
My lord, by that time,
let's get down to the actual fact of the matter. Are you saying they have complied with the judgment or they have not complied with the judgment?
No, they have not complied with the
What
judgment.
is your remedy if
My-
the judgment is not complied with?
My lord, the order was passed on 16/10/1990. They have issued this lease deed on 1/10/1992. By that time, the period for contempt has already over.
No, you're wrong, sir. In fact, I don't think we should be giving you legal advice. The cause of action for contempt arose when?
My lord, if they
The
have
cause
not
of action for the contempt petition arose when, sir? When this lease deed was executed?
my lord,
So your cause of action, if it arose on the date of this registered lease deed, when should you have filed a contempt petition?
within a period of 1 year.
Did you do that?
I have not done that.
Now you
Yes,
come
it
with
is
the
a
writ
fact, I
petition
have not
after
done
when? You come with the writ petition after 11 years.
Obliged.
And there is no
True, my
stay
lord.
order here.
My
There is
lord,
no stay order. Your petition is barred by 11 years, and you think you can walk anytime into the court, keep it pending. After some 20 years, some division bench of the High Court will just give you the land. Do you know what the value of the land today is, sir?
no, my lord, this is a list. I am continuing as
What
a
is the
lessee.
value of the land, sir? Where is it located?
It is in a remote area of Titlagarh in the district of Balangir.
Is it worth 300 rupees or slightly more than that?
No, it will fetch positively more.
What is
This
it
list
positively
did,
more?
my lord,
Just give us an idea. I'm new to Orissa, sir.
My-
I'm completely
my lord,
ignorant
the-
of facts of Orissa. Please tell me what is the land in Titlagarh worth?
my lord, a
Land.
permanent list
What
is
extent of land, sir? What is the extent of land, Mr. Samal?
only 14 decimal.
Only, okay. All right. So what is the worth of this land?
I cannot say.
No, your client can say, sir. Maybe you cannot say. He knows the value of this litigation.
My lord, a lease deed has been granted in my
Then
favor.
you missed the bus for 10, 11 years, you missed the bus. All right. One fine
That's
day,
it.
your client decided to walk into Mr. Samal's office. He said, sir, find a solution. Mr. Samal said, forget contempt and all that. We'll file another writ petition.
My lord, 1 minute, my lord. My lord, the opposite parties are the state authorities. They have been directed to settle the land as per the order of this honorable court. The OGLS Act only prescribes one mode of settlement with the status of the royalty status. That has been mentioned as per the rules. Rule 5D provides that of Schedule 5 provides that the settlement of the land under schedule shall be made on royalty basis on payment of the salami and rent. But they have granted the lease deed. This is the only complaint. The land is mine. They have settled. They have leased out the land in my favor. But
Do you
he
want
is
to
a
withdraw
poor
this
man.
writ petition, sir? Do you want to withdraw this writ petition? You seem to be in a very happy position. Nobody's disturbing you. It's almost like the land is your own.
Your lordship may give me liberty to approach the competent authority. Well, in fact, he is a
Withdraw
poor
this
man.
petition with liberty to approach the authorities in accordance with law. Dismiss is withdrawn with liberty is paid for.
Item number 6.
Counsel, the petitioner states the petition has been rendered infructuous.
Item number 7. Item number 7.
None appears dismissed on opposition. So you'll have to speak near the mic, sir, if you do not mind. You can walk to your right, sir. Walk to your right. To your right, sir. And you speak into the mic, sir. So you'll have to speak into the mic. My hearing is not very good, sir.
Item number 7, I am for the opposite party, one Chittaranjan Panda.
We'll first talk about the petitioner, sir. You are for the opposite party, no?
He did.
1 minute, sir. 1 minute. Let us see who's for the petitioner. Just call out the matter again.
Item number 7. WPC 10585 of 2004.
None appears for the petitioner. Dismissal not opposition.
Item number 8.
Wait, please, Your Lordship. Your Lordship, item number 8 in the first.
My lord,
matter-
sorry, my lord, I am for item number 7, my lord.
All right.
My lord, item number 7, I am excused, my lord. I may be excused. I could not
Excuse
join.
me,
it.
what?
Item number 7, my lord. I am for the petitioner.
Yes.
My lord, in this case, my lord,
Yes.
I have filed 2 IA.
Yes.
One is 11554
Yes.
of 2021.
Yes.
And the other is the IN number 11556 of 21.
What is the extent of delay, sir?
Delay, sir, I have recently came to know, Miller. The
No,
petitioner
whenever
is
what is the, tell us the delay, sir. Tell us how much is the delay.
My lord, the matter has been earlier listed on
Kindly
July
answer the
21.
question.
My lord, the matter has been listed on July 21. So I took time, my lord.
Kindly answer the question, sir.
Yes,
what
my
is the
lord. So
extent of
July
delay?
21, my lord, July 21 I inquired that he is dead. So from July I filed it on.
Sir, tell us the number of days of delay. Sir, you are such a seasoned senior lawyer. You should know this. What is the extent of delay, sir?
Delay, sir, that from July to 19 August, sir. July 21st to 19th August, my lord. The
2 days
application.
delay, 1 month delay, is it according to you?
Yes, my lord.
When did the man die, sir?
Man died, sir, exactly.
You don't even know that.
No, my lord, I have not stated it, but I could not get it, my lord.
Not disclosed.
So we don't mention the date of death. You don't mention the date you came to know, but you filed an application for condonation of delay. It's very convenient, sir. And when the judge asks you, simply say, I got to know only last month.
So, my lord, I may be permitted to give time.
No. Let us get down. What is the case about?
My lord, the case is about the property of a DT, my lord.
Yes.
That is Siddheshwar Mahadev at Sambalpur, my lord.
Let's see the impugned order, sir. Which is the order you have challenged?
Order of challenge here is, my lord.
Annexure
9. My lord.
Annexure 9.
Yes, my lord.
So tell us what is wrong with that order.
My lord, in that order, first ground is that this revision petition under the OEA Act has been filed after 15 years of the appellate order without there being any application for condonation of delay.
All right.
Second, my lord, in this revision, the present petitioner has not been made a party. Having come to know about the same, he applied for being a party and he was allowed and he filed the written statement also, my lord.
Right.
My lord, the matter is very old, my lord. Earlier, my lord, it will be very convenient if your lordship may permit me to pay for listing of this application, my lord, along with these two applications, my lord. One is OJC number 421 of 1970 in this honorable court, my lord. This matter has already been decided. My lord, OJC number 421 of 1970 decided on 4/8/1972.
Sir, you continue arguing and telling us what is wrong with the impugned order.
My lord, the law and the facts that decided in this case, my lord, that are not at all been taken into consideration by the revisional authority.
It has been mentioned, in fact, in both paras 8.1 and 8.2.
And more particularly, your lordship will find
My lord?
9 to internal page 7.
Yes,
The
I'm
matter
on
has
that
been
only, sir.
remanded.
I'm that only.
Matter has been remanded to
No,
the
and para 5, they note this. Para 6, they note this OJC. Everything is noted.
Yes, everything has been discussed.
So you will have to tell us what is wrong with the impugned order, sir.
My lord, impugned order first thing is that, my lord.
Yes.
As I submitted before lordship.
No, don't repeat. If you're saying about delay, that's on,
yes, my lord.
On merits, what is wrong with it?
On merit, my lord, he has simply passed the order on his conjecture and surmises, my lord, ignoring the law already decided by, in this case, my lord, Honorable Supreme Court, my lord, this fact has already been, this case matter, this property has already been subject to litigation since 1960, my lord.
No. Please proceed, Mr. Jana. You have nothing more to add, sir? You tell us.
Yes, my lord. This property, my lord, very property, my lord, has been subject to litigation under the OEA Act, Orissa State Abolition Act. So in that case went against the opposite party divisioner, which was the divisioner in OEA case, my lord. So he applied for appeal. He went into appeal. The appeal was also dismissed. So he left that proceeding there. Then he initiated a proceeding under the Orissa Hindu Religious Endowment Act, 1960-64, I have written all the things, all the governments are there. So in that case, the Commissioner of Endowment passed order in his favor, directing the collector to take possession from me of that land and to deliver to the opposite party endowment, DT Miller. So I preferred Miller OJC number 421 of 1970 against that order, which was allowed by this honorable court on 4/8/1972, Miller. Miller, the revisionist Miller went to the Supreme Court, Honorable Supreme Court, Miller. There his special leave was dismissed. So Miller, which that always there in the government, Miller, my government. So Miller, thereafter he left there. Then again he went to another proceeding under Hindu Religious Endowment Act, Section 41A. That case was decided against him. And then I went for Commissioner Miller, Endowment Commissioner in appeal. That appeal was allowed in my favor. Then they went, misappeal number, I was submitting Miller, misappeal number 92 of 1987, decided on 10/2/1993 by this honorable court. And by this case, their miscellaneous application was dismissed. Against that order, they went to special leave to the Honorable Supreme Court. The Honorable Supreme Court dismissed their special leave petition. So the matter concluded twice, Miller. Again, after this, Miller, they surreptitiously filed OEA division without disclosing that about all these proceedings and the results thereof. And the commissioner, member Board of Revenue, Divisional Authority, without considering all these things, Miller, he passed on its own that the DT has not been DTC property. It should have been so and so, but completely ignored the final things, Miller, which had been concluded against the DT and its managing trustee, Miller. So, Miller, that is one thing, Miller. The second thing, Miller, after this, I have filed this writ application 10585 challenging the order of the Revisional Authority, entirely on the ground that these things are, first of all, it is barred by limitation, 15 years delay of appeal after appeal. And second is that since the matter has been concluded by this honorable court as well as the Honorable Supreme Court, he has no jurisdiction to enter into this. And third thing is that, Miller, the OEA revision also not maintainable in law because that has already been decided in a number of cases, Miller. That's the case, Miller. Miller, after the revision was allowed, the impugned order was allowed, Miller, the managing trustee and some members then went and filed an application of settlement revision before the Joint Consolidation Commissioner on Settlement, Sambalpur. Though in that case, the postal record of right has been issued in my favor in 91, 82, 83. They challenged this on the basis of this revisional order. And the Settlement Authority, the Commissioner Miller, Joint Commissioner, he allowed that prayer and directed lower authorities to correct the record of rights. So against that, Miller, I have filed the other writ application, that is 3082 of 2005, Miller. So, Miller, this second writ petition, Miller, is that about challenging the order passed by the settlement authority, settlement commissioner, whereas the first was against the revisional order passed by the member board of revenue. All these things have, all these courts, not lower court, have ignored these facts, even if those facts were brought to their notice that the matter has been concluded. And again, my lord, that the criminal division which has been filed and has been tagged with this opposite party, managing trustee and some other public members claiming to be the Hindu public, they created law and problem. So as a result of which the authorities, executive authorities, initiated 144 proceeding, which was later converted to 145 proceeding, and these parties, those who were second party in that case, they did not appear, they did not file any written statement, they did not adduce any evidence, whereas the present petitioner as the first party entered into appearance, filed its written statement, examined himself as a witness, and filed all these documents as decided up to Supreme Court before the authority. But without considering that thing, the executive authority passed the order that since there is a breach of peace, the order will continue. Ignoring the number of facts, that I am in possession, they were trying to take forcible possession, all these things. So that is challenge under criminal revision number
488 of 96.
Yes, my lord, 1896.
Sir,
So,
with your permission, can we ask the other side to argue also, sir?
yes, my lord, that's
Mr. Mohanty, please.
Yes, my lord. My lord, your lordship may kindly see. Basically, this is a dispute between the DT and the private petitioner.
Yes.
And the DT, in the impugned order, what your lordship will find, the matter was only remanded because if your lordship will see the first para of the impugned order,
Yes.
the appeal was abated. No
Yes.
effective decision was made by the appellate
Correct. Because the
authority.
trustee died.
Yes.
Yes.
That is why the revisional court
Correct.
after
So
discussing
there's nothing decided on merits.
nothing decided. It has been let him take part before the
Correct.
original.
So at least
authority.
one court has to examine the documents and decide
Yes,
on
my lord.
merits.
Yes, my lord. Let him appear before the OA authority and place
Correct.
all these points before
Correct.
him.
Correct. No prejudice is going to be caused.
Yes, my lord.
Right.
Because it is a question of remand
Correct.
only.
Yes, Mr. Jena. Anything more?
yes, my lord. My lord, after remand, my lord, they filed, as I submitted before your lordship, that they filed settlement revision, wherein the settlement authority, instead of considering the matter on merit, my lord, he decided to
That is the
cancel my
consequence
potas,
of the
my lord.
first
He
read
cancelled
order.
my record of rights, my lord, though he had no power. In the order of remand, my lord, the remand was made to OA authorities to consider the case, not that the divisional authority under Settlement Act to
So we'll
cancel
give
the
effect to the
quota.
remand order. The other order can stay in abeyance till the remand is decided. All right.
My lord,
The order in the settlement proceedings will stay in abeyance till the remand is decided.
Yes, that can be done.
may I
We'll
submit,
write
my lord?
the order, sir. We'll write the order. Ah,
May I submit, my lord?
I need pardon, my lord. In this case, I was appealing for the managing trustee.
whatever, sir, we're not interfering with the impugned order.
My lord,
Sir, we are not interfering with the impugned order.
My lord, the matter may be placed tomorrow, my lord. I will convince in physical court, my lord, that
Not
his
necessary,
order,
sir. Not
My
necessary,
lord-
sir. You have been very eloquent. Not a problem, sir. Not a problem.
my lord, this matter has been concluded by the Honorable Supreme Court, my lord.
Very well, sir. We will deal with all those points. Not to worry.
Item number 8.
my lord,
Sir, you are for the opposite party, correct?
one of the.
We are deciding in your favor, sir.
Yeah.
You still want to argue?
That person. that-
We are deciding in your favor and you want to prevent us from doing that?
No,
Call out the next matter.
Item number 8. WCC 13159 of 2004.
Wait, please, Your
My
Lordship.
lord,
Your Lordship, it's a batch of matter, my lord. The first
my lord,
matter-
may I be pardoned, my lord?
Yes.
My lord, in the item 8, there are 4 writ applications. In
Yes.
3 writ applications, the brief has been transferred. Our names may be deleted.
All right, sir. Yes, tell us.
my lord, in
My
the
lord,
first writ petition.
My lord, I
Devendra
will-
Mahanta and Jagannath Patnaik.
All right.
My lord, the
My lord,
first
I will be pardoned, my lord. The item, last sub item,
WPC 5432 of 2019. That is my writ application, where I challenged the withdrawal notification of section 31 of the Contract Labor Abolition Regulation Act 1970. But on 9th of February, the opposite party, Paradip Port Trust, issued a letter to the private contractor, whereby our services will now be transferred to a private contractor, despite abolition notification way back in 2001, my lord. I filed an application IA number 2241 of 2022 that has not been listed, my lord. You may kindly call for that IA.
All right.
In the first writ petition, my lord, I'm the petitioner, my lord. In the first, which is a 2004 writ petition, my lord, there we had come against the show cause issued by the Regional Labour Commission, my lord, for taking criminal action against us. My lord, this court had given us interim stay against proceeding to be done against us. My lord, what has happened in the meantime is, my lord, may kindly see OP number 3 has filed a counter. If my lord has a glance at page number, internal page 9 of that counter, my lord, the very end of that page, my lord, what has happened in the meantime is, my lord, in 2004 we came in. Our ground before the Regional Labour Commission was that we had written letters to Ministry of Shipping. It's actually in the internal intra-ministry discussion. So Ministry of Shipping was still writing to a Labour Ministry, my lord. My lord, so while this case was pending in 2009, my lord, in a letter dated 2nd April 2009, my lord, if I may read out the last portion of the Ministry of Labour and Employment letter. In the circumstances, it may be appreciated that the notification dated 4/7/2001, which we are in violation of, that's the allegation, can neither be amended nor withdrawn. So they made it clear that that has to stay. My lord, after that they write, however, the matter regarding violation of the said notification has been referred to the Office of the Chief Labour Commissioner, Ministry of Labour, and to look into the matter and take necessary action. So, my lord, even if in 2009 they reiterate that 2001 will apply and will continue and no amendment will take place, they have sent it, our violation, if at all the alleged violation, to the Chief Labour Commission, my lord. That I have got no instruction of, my lord.
So it's premature. So whenever they take a decision, you can revive.
My lord, only either that, my lord, or my lord, if as your lordship pleases, my lord. If at all after this letter, if they have taken any action, my lord, I may.
Writ petition 13159 of 2004. The challenge in this petition by the Paradip Port Trust is to the communication dated 2nd September 2004, sent to it by the Office of Labour Enforcement, bracket Central, Ministry of Labour and Employment, Government of India, asking the petitioner to show cause why legal action under sections 23 and 24 of the Contract Labour, bracket Regulation and Abolition, bracket Act 1970 should not be taken against it. Paragraph. Mr. Soumya Mohanty, learned counsel appearing the petitioner, draws attention of the court. The counter affidavit filed
OP number 3, my lord.
by the union, is it?
My lord, the union.
By the Paradip Port and Dock Mazdoor Union, bracket opposite party number 3, stating that bottom of page, para?
My lord, para 3, letter dated 2nd April 2009, my lord. Annexure C by 3.
Referring to a copy of a communication dated 2nd April 2009 of the Ministry of Labour and Employment, addressed to it, stating that the matter regarding violation of the notification prohibiting employment of contract labor has been referred to the Office of the Chief Labour Commissioner, bracket C, Ministry of Labour and Employment, open quotation, to look into the matter and take necessary action, unquote. Mr. Mohanty states that he is not aware of the outcome of the above reference paragraph. In the circumstances, is directed that as and when the matter is decided and a communication is issued to the petitioner, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
My lord, my only prayer, my lord, is the annexure 9, which was impugned. There may be some observation on that, my lord,
You say
in respect of that.
petition to revive the challenge to Annexion 9 depending on the outcome of the above proceedings. Yeah.
Grateful, my lord. Grateful. My lord.
Appearance of Unionopinion noted by RHCJ party.
What about this next writ petition, 2013?
My lord, 2013, my lord, I am the opposite party, my lord.
That
has been
Mr.
filed.
Devendra was mentioning, my lord. That file has been transferred from him.
Yeah, so it's okay. Say counsel for the petitioner states that the file has now been transferred from him.
No, my lord. One Mr. Bibi Rautra is appearing after the transfer, my lord.
He's not there today, sir. We cannot wait for him.
I'm sorry. Yes, my lord. I don't know, but our name may be deleted.
So
Mr.
we've
Jagannath
already done
Patnaik.
that. Sir, don't be so
Yes.
anxious. We've already noted it.
Obliged.
Right at the beginning, you say Mr. Mahanta states that he has withdrawn, his papers have been withdrawn from him. And papers were entrusted to Mr. B.P. Rautre. Today, none appears for the petitioner, dismissal, non-prosecution. It's 2 and 3. All right, last 1790 also. 5432.
1790, I am appearing for the port trust.
All right, sir. So
The
5432. 5432.
My lord, I am the petitioner, my lord.
Tell us.
I just have a submission. There is a interim order in 1790 that stands.
Sir, obviously it will go, sir.
I am deeply obliged.
All right.
My lord, in the 5432 last sub item, my lord, am I audible, my lord?
Of course, sir.
My lord, at page 20 under annexure 1,
yes,
on 4th of July 2001, a
Yes.
notification under section 10 of the Contract Labor Abolition 1970 Act was issued,
right,
abolishing the contract labor at Paradip Post IOSP plant with regard to mock cleaning and spillage removal, my lord.
right.
My lord, sometimes in annexure 2 at page 21, a notice was issued.
Sir, you're resisting your services being placed at the disposal of another contractor, correct?
Another now, my lord, that is why I am
1 minute, sir. 1 minute, sir. 1 minute. If you do not want to work with that contractor, is there a compulsion in you to work?
My lord, contract labor has already been abolished. Our services have been
Sir,
taken.
just answer the question.
My lord,
Are you under compulsion to work under the new contractor?
my lord, that is what they have said.
No. Who's that they to say? I'm asking you.
Yes.
You are how many petitioners? 23 petitioners.
23 petitioners, my lord.
Are these 23 petitioners being compelled to work for a new contractor?
Yes, my lord.
No. There's no such compulsion. Please do not make submissions like this.
My lord,
You're not understanding the purport of the question, so you're blindly saying this.
No.
There is no compulsion. If you do not want to work under the new contractor, there's absolutely no compulsion.
My lord, may I submit, my
Record
lord?
a statement that you do not wish to, and we'll say nobody can compel you.
My lord, for a moment,
Allow that prayer. If you are under the apprehension that you are being compelled to work with a new contractor, we'll say you're free not to work.
my lord, that the document which says compelling circumstances, that is
No. That is very different, sir. You're misinterpreting.
No.
None of you individually is being forced to work for anyone. If you are under that misimpression, we'll clarify that nobody can force you to work with a new contractor. And that will be the end of the matter.
Yes, my lord.
That's the only relief you want, correct?
No. I have a subsequent prayer. My prayer is after abolition in 2001 and after the exemption
Then
granted.
the sale judgment will apply whenever it opens up, you'll get absorbed.
My lord,
Yes.
my lord, here
Yes.
I'm appearing for the port trust.
Yes, my lord.
Yes.
My lords may kindly see
Yes.
page 24, annexure 3.
Yes.
Now, this exemption which was thought to be challenged before this court,
Yes.
that was for a period of 2 years.
Yes. That's over now.
That's over now.
So
That
it's
is one.
infructuous.
Yes, and in any event, this is pro workers. The new tender it's up to them if they want to work, they will be given all the work. The port actually wants to give them work. If they don't want to work, there is no harm.
No. Mr. Mishra, his contention is in your establishment, contract labor is now prohibited.
My lords.
So he says if it's prohibited under sale judgment, they are supposed to get absorbed.
Now the tender given to the private.
So as and when you go for regular recruitment, you can absorb them, correct?
Correct, my lord. Now the tender.
Since you're only going for contract labor, then how are you permitted to go for contract labor? That's the question he's asking.
Now, so far as this case is concerned, this 2-year period is over. So this is infructuous.
No.
And so far as the tender given to a third party, that is sub judice in another writ petition.
No. Mr. Mishra, the question is simple.
My lord.
Your exemption has come to an end, correct?
My lord.
Which means the ban is in place.
Yes.
How are you now issuing advertisements for contract labor? That's the question.
Now, that issue is pending in 2 other writ petitions.
No, it may be pending anywhere else. He wants to know why are you still engaging contract labor instead of absorbing him.
Now, in that tender condition, there is a clause that they can be engaged, and we will ensure that they will be engaged.
No, engaged on contract labor basis is the problem.
Yes.
So, my lord, there the sale judgment will apply. As your lordship says, the sale judgment will apply. As and when it comes, we will absorb.
So we'll record that statement.
Now, the problem here is this matter, the period is over. That is one. And second is they are apprehending in the IA, that IA, whether it has come or not, I'm not sure. IA number 2241 of 2022.
No, there we'll record the statement that none of them wants to work with the new contractor. That's it.
No, but he is speaking for 23. There are others.
No, we'll record these 23 do not want to work. That's the end of the matter.
In fact, my lords, their IA is otherwise. In the IA, they say that they fear losing their jobs.
I don't know. Mr. Digambar Mishra seems to be very confident that these people do not want to work.
In fact, it would be beneficial if they continue to get...
No, but he is very clear. He says, who can compel me to work? I don't want to work. So why should anyone
that is
compel
not mandatory as per the terms.
That's right. So we'll record his statement that they do not wish to work for the new contractor. That's the end of the matter.
My lord, with that, then my lord, it may be detrimental to his clients. I don't know why he's
No. He's obviously making a submission after consulting them. So we should not presume that.
The new contractor has already applied for gate passes. He will give them work. That's what my instruction
We'll record Mr. Mishra's submission. Mr. Digambar Mishra will record your submission that none of these 23 persons wish to work for the new contractor, correct?
My lord.
So record a submission. That's the matter.
My lord,
and that you will await, whenever there's a regular recruitment, you will await your turn and as per the sale judgment.
My lord, deeply obliged. My lord, 1 minute, my lord. The IA which I filed on 9th of February 2022, in that I have annexed a document which my friend is also referring to. That you will kindly see for a better picture, my lord.
No, better and all. You're there, sir. You're giving us the best picture. You tell us.
My lord, yes, definitely. In terms of sale judgment, I have to be now. My services will be ease now continuing under the Paradip Port establishment. I should not be disturbed.
No, you're not continuing, sir. There's only a contract.
Yes, we are continuing, my lord. We are continuing.
Sir, as and when Paradip decides to regularly recruit, they will give you the chance as per sale judgment.
No, our services have not been dispensed with, my lord. We are still working.
Your services are with the contractor, sir.
No. We are under the establishment of Paradip Port.
No, sir.
Yes, my lord.
No.
Let them file that.
Show us a payslip given. Show us a payslip given by Paradip.
Paradip, yes, my lord. I will file
which annexure? No, which annexure is a payslip from Paradip?
My lord, payslip I have not annexed now.
No. This kind of a matter you can't make such a casual submission, sir.
They are working through cooperative.
I have gone to the
this
court.
Kind of a matter, your assertion that I'm working for PPT directly as my employer, you can't simply make such a submission without even a payslip.
My lord, for a moment you will see me kindly.
If this contention is accepted, then this writ won't have come into place. Then what's the meaning of this writ?
Yes.
Correct.
I have come to the court challenging the exemption notification, my lord.
Correct, sir.
Yes,
exemption notification.
So let us understand this. This whole matter is a contract labor matter, correct?
Yes, my lord.
I'm a third year BL student, sir, LLB student. I'm completely ignorant. You educate me now. All right.
My lord.
In a contract labor matter, are you directly employed by the principal employer, sir?
After abolition of the contract way back in
There's no automatic absorption after sale, correct?
After sale, there cannot be a concept of regularization. In the event, they violate they make unfair labor practice. then they have to do industrial standing order rule Act 1946 2A. Schedule. If they violate, my lord, they have to give us the preferences to us in terms of the
violate, sir. Violation has a separate enforcement provision.
Correct.
Unless they go in for a regular recruitment, they are not obliged to absorb you.
My lord, for a movement, Annex 3 at page 24, you will kindly see.
So why was Air India reversed? Or am I wrong? Completely wrong.
No, that has been now.
Air India is a 3-judge bench judgment. SAIL is a 5-judge bench judgment. Correct?
Correct, my lord. Now
and SAIL overruled Air India.
No, Air India, that has been overruled. Now, as per the judgment of my lord Justice Chandrachud, the matter is pending before the larger bench, my lord.
Let it be, sir. There is no stay of the SAIL judgment.
No, there is no stay of
so then what is the law, sir?
This waterfront will prevailing, my lord. Now, my question is, the last line says, subject to the condition that Paradip Post establishment shall pay basic wages to the workers and supervisors with all other allowances are as being paid similarly placed workers under the societies in the Chennai Port Trust and Vizag Port Trust. Meaning thereby, our services has not been dispensed with by the Paradip Port Trust.
So you show us a pay slip of Paradip Port Trust. Show us a pay slip issued to you by Paradip Port Trust.
Well, they have also denied in the company.
No, sir, please. Like I told you, I'm a very poor student of contract labor law. I ask very basic questions. It might look very basic, but it's a basic question.
Basic question, I'm answering.
I want to know if Paradip Port Trust is directly paying you. Show me the pay slip.
No. I will submit my attendance. They are taking our attendances.
Sir, attendance has to be taken. After all, you'll be working in the establishment. Of course, attendance has to be taken.
No, the principal employer has to file a return to that effect, madam.
Sir, are you directly employed? Why is this concept of principal employer? You tell me. Why is this concept of principal employer?
Madam, contractor is an agent of the principal employer. Here, the principal employer is the Paradip Port Trust, and the principal employer is the Paradip Port Trust itself. Correct. And they are taking our attendances. Now, under Annex 3, when the exemption, that notification came in, thereafter, they have taken our attendances and our services has not been dispensed with, and we are still continuing.
All right.
May I suggest that the impugned order has lost its force?
Correct.
This is basically an infructuous rate.
We are recording all that. You see, the challenge in this petition is to a notification dated 9th October 2018, issued by the Ministry of Labour and Employment, Government of India, exempting Paradip Port Trust from the applicability of a notification dated 4 July 2001. In respect of employment of contract labor in the works or jobs of iron ore, muck cleaning and spillage removal work in the iron ore handling plant of Paradip Port Trust (PPT) for a period of 2 years with the effect from the date of the publication of the notification. Paragraph. Mr. Gautam Mistral and senior counsel appearing for PPT at the outset points out that the aforementioned notification is now worked itself out as the 2-year period has come to an end. And full stop, he states that on that short ground, the writ petition should be disposed of as having become infructuous. Paragraph. The above submission is opposed by Mr. Digambar Mishra, Honored Counsel appearing for the petitioner workman, who insists that the services of the petitioner placed at the disposal of the PPT have not been dispensed with, and that they should be held to be continuing with PPT as the single quotes principal employer. It is also pointed out that in the meanwhile, an advertisement has been issued for engaging fresh contractors for supply of labor.
No advertisement, my lord, I'm going to pardon. No advertisement issued.
Okay.
Tender notice has been floated and some...
What notice has been floated?
Tender notice, madam.
All right, a tender.
Tender notice.
Tender notice has
engaging a private contractor.
All right, a tender notice has been floated for engaging a private contractor, and an attempt is being made to place the services of the petitioners at the disposal of such private contractor. Full stop. Paragraph, the court repeatedly asked Mr. Mishra, Mr. Digambar Mishra, whether the petitioners are unwilling to work with a new contractor, with a such private contractor, and he answered in the affirmative. Full stop. The court clarifies that the petitioners are under no compulsion to work for any private contractor. Paragraph. As regards the plea of Mr. Mishra of the right of the petitioners to get absorbed on a permanent basis in PPT, after the judgment of the Constitutional Bench of the Supreme Court in Steel Authority of India Limited versus Union of India, you have the citation.
National Waterfront. National Waterfront.
2000.
What's the citation, Mr. Gautam Mishra?
AIR 2001 Supreme Court.
Is it the sale notification, sale judgment Malad is asking about? 2001 7 SEC, page number 1.
2007 SEC.
2001 7 SEC.
As and when PPT goes in for a regular recruitment on regular basis, preference will be given to the present petitioners since they were working on contract labor basis earlier with PPT. No other clarification is called for. The petition is disposed of.
One prayer, my lord. One little prayer. The other areas and differential wages may be paid.
No. That is not even the scope of this petition, sir.
My lord, I have prayer number 3 is there.
No, you'll have to institute a labor dispute for that, sir.
No. After consequent upon the abolition, since 2001, the differential wages be paid.
No, sir, that's not such a simple matter. It will have to involve examination of evidence on individual workman basis. They'll have to separately file applications for that. Yes.
That
all right. Any other prayer in the present petition can be sought in other appropriate proceedings in accordance with law. Yes.
Item number 9.
My lord, one little prayer. Till there is no our status quo with regard to services shall be maintained.
No, sir, no question. Call out the next
item number 9.
Item number 9. And for the appellant, my lord. Annexed 8 is the judgment against whom I have filed this appeal, my lord. I have received counter of the today, my lord. May I pay?
All right. List before it, bench of with Justice R.K. Patnaik, not a member. On 22nd March.
Item number 10. Item number 10. Item number 10, WPC 1670 of 2005.
None appears. Dismissed for non-prosecution.
Item number 11.
May I please, your lordship?
Yes, please.
Well, the petitioner, after the death of his father, who was serving as a primary school teacher, applied for appointment under the rehabilitation assistance scheme against a class 3 post, because by then his qualification was HSC. Due to non-availability of a class 3 post, he was given appointment against a class 4 post, my lord, on 2784. Then he went on making representation, and ultimately, with the permission of the director, the inspector of schools appointed him in a class 3 post, that is against the post of a junior clerk, on 26/1987 under Annexure 3. My lord, and he joined against the post of junior clerk on 7/7/87, and he continued to discharge his duties as a junior clerk. My lord, one Manoranjan Patti, who was appointed against the post of, who was appointed against a class 4 post because at the relevant time he didn't have the requisite qualification. He had not passed HSC. He passed HSC examination in 1992, much after his employment. Then he approached the tribunal claiming parity with me that he should be given appointment as a junior clerk. Well, the tribunal directed for consideration of his case. Then the inspector of schools, my lord, in his report has categorically stated that the case of the petitioner does not stand, the case of Sri Manoranjan Pati does not stand at par with my case because Sri Manoranjan Pati didn't have the requisite qualification at the time of his appointment, whereas the petitioner, the present petitioner, was having requisite qualification. Thereafter, he again filed another way, and in that way, direction was issued to consider his case. And my lord, thereafter, my lord, I am told that his case was considered and he was given appointment as a junior clerk sometimes in 2012, etc. I have filed an additional affidavit, but that additional affidavit is not
you're
available.
challenging. So you're challenging
Yes.
an order of the Orissa Administrative Tribunal.
No, my lord, I am not challenging the order of the tribunal because in that case, although I have challenged, my lord, as a mark of abundant caution, I have challenged.
What is this? A mark of abundant and all? Just come to your
Because
prayer
in that
class.
case,
Just come
I
to
was
your
not
prayer
a
class,
party.
sir.
Yes, my lord, your lordship is correct. In that case, I was not made a party. But because of certain
No,
observations
should we
made by the
record the
tribunal,
fact that your prayer class is a mistake? That will end of the matter then.
No, my lord, I have challenged.
When I
three
asked you
orders.
pointedly, you have challenged
Yes.
an order of OAT, you said no,
Yes, absolutely
Now
correct.
it's become yes.
No, my lord, absolutely correct. I have challenged certain observation made by the tribunal, although in that case I was not a party. But the main order which I have challenged, that is under Annexure 8 at page 28.
That's a consequential order implementing the order of the OAT.
Annexure 8 at page 28.
Huh.
At page 28. Now, your lordship may kindly see the order of the tribunal. My lord, your lordship may kindly come to page 22, Annexure 5. That order was passed in the case of Manoranjan Pati. In that case, I was not made a party. He claimed parity with me. May I place that order? My lord, may I place that order?
Sir, all that this order at Annexure 8 says
Yes.
is wherever you detect an illegal appointment, give a show cause notice and then hear the person and do whatever you have to do.
My lord,
What is wrong with such an order? It's the most innocuous order, if you ask me.
My lord, your lordship is absolutely correct. Your lordship is absolutely correct. This order was passed sometimes in 2005. My lord, that is 18 years of my appointment. I was appointed on 26/1987 against the post of a junior clerk under Annexure 3. Your lordship may, for a moment, your lordship may kindly see Annexure 3 at page 20. Annexure 3 at page 20.
You're not telling us what is wrong with the tribunal's order.
Well, the tribunal's order, your lordship may kindly see. How could the tribunal, when in that case I was not made a party, how can the tribunal made an observation to terminate
What
my
is the
services?
observation? Let us see that observation.
Yes, Annexure 5 at page 22. Therefore, my lord, I am taking to your lordship the tribunal's order.
Para 3. Come to para 3.
Once an appointment is given in a class 4 post, the application of the scheme or rules is exhausted. There is no further question of any other higher appointment.
Not directed at him.
If a post is available, the director's instruction to the inspector of schools to give appointment at junior clerk afresh to persons who had been appointed in class 4 post is not justified. I call upon respondent number 1 to examine the appointments and if necessary direct terminating the same after giving them opportunity to so cause, so that the applicant and others similarly situated will not have such a grievance. If, however, appointees are
what you
not
have successfully
terminated,
done, Mr. Swine,
my lord,
what you have successfully done is these were all innocuous observations, completely innocuous, not directed
Yes.
at you at all. It wasn't directed at you at all. It was for anyone and everyone who may have just moved from class 4 to class 3 on
absolutely
their own.
correct, absolutely. My lord, I
It was not
completely bow
directed
down
to
to
you,
your
but look
lordship's
what you
observation.
did. Look what
My
you
lord,
did. You came before us when you were only 42 years old. You got a status quo. You're now going to retire in a few months, correct?
Yes,
Or
yes,
you
absolutely
retired
correct. And in the meantime, I have got promotion to the post of senior clerk and head
come to
clerk.
your great rescue. We have come to your rescue by passing
My lord,
a stay
absolutely
order
correct, absolutely correct.
and letting it remain for the last 17 years.
Well, your lordship may kindly see, in the meantime, I have got promotion to the post of senior clerk in 2006
No, you
and to
have
the
even
post of
become,
head clerk in
for all you know, you have become
2015.
a director also, sir.
Well,
Thanks to the stay
2015.
order, you went up and up.
No.
Yes,
Well,
yes.
your lordship may kindly see. In that case, I was not made a party, but some innocuous observation was made.
No,
And basing
even an
upon that
innocuous order, you got it stayed.
No, because of
And
the
state
innocuous
government is
observation.
very, very obliging.
Well, your lordship, my lord, well,
Just
what
what
is
has
my
happened,
fault?
just see this case. This is never going to be inquired into now. When we dismiss this writ petition, nothing. By the time they communicate this to the government, by the time the government understands, the government decides to do something, you would have retired.
No, my lord, I have 2 years
Yes.
left. Now I am
You can
58.
be sure
Now
of
I'm
that.
58. Now I am 58, my lord. I have 2 years left.
No. I mean, your age is 42 in 2005.
2005.
My arithmetic is bad, I know.
One year.
Please, now I'm feeling reassured that all those maths teachers did not waste their time on me.
My lord, your lordship may kindly see I have given a memo where, my lord, I have got 2 promotion to the post of senior clerk as well as to the head clerk. Senior clerk, I got promotion in 2006.
So you must have gone even further, actually.
In 2015. And what is my fault? With the permission of the director, they have done it.
Correct. So whenever that show cause notice, whenever that you get, whenever you reply, whenever they decide, you will cite all this before them.
Well, your lordship may kindly see Annexure 2 at page 19.
So you did not even allow a show cause notice to be issued to you. So still a long way to go, sir.
Now, my lord, I am at the fag end of my service career.
No.
And I have got 2 promotions.
Of course you are.
I have got 2 promotions to the post of senior clerk as well as to the head clerk.
Yes.
And if at this juncture, my lord, anything happens
What will
adverse
happen,
to me,
sir? What will happen? One show cause notice will be issued, to which you will reply. Correct?
my lord, the show
And
cause
then they will have
notice
to sit
was
and decide. You know
My lord.
how quickly they move in these matters. You know that, no?
my lord, Annexure 8 that was issued way back in the year 2005.
All right. You have done your bit, sir. We have come
My
to
lord.
your rescue for 17 years now.
Well, your lordship, may I suggest one thing?
Yes.
My lord, your lordship may kindly see the memo which I have filed today. My lord, your lordship may kindly. My lord, I have got promotion to the post of senior clerk way back in the year 2006.
Sir, I think,
and to the post of
you will
head
be
clerk.
very happy if we allow this petition and say that please grant him 3 more promotions. Correct?
My lord, and so far as my lord, my another contention before your lordships is, my lord, I am not wasting your lordship's time, but I am seeking your lordship's indulgence. My lord, to a man's plight.
Indulgence was for the last 17 years was total indulgence.
My lord, your lordships is absolutely correct, but that is my duty and I have done.
No, that is right. We don't see the problems of the system is our problem. So it's never your problem.
My lord, now your lordship may kindly see because of this development.
Yes.
And my lord, in that case, I was not made a party. And some innocuous observations were made on the basis of that innocuous observation. And the person, my lord, who claimed parity, in the meantime, he has been appointed as a junior clerk.
All right.
His claim has also been redressed.
All right.
And now I have been made a scapegoat because of Annexure 8.
Sir, somebody hears that on a 17-year stay order, somebody got 2 promotions and still calls himself scapegoat, they will have some difference of opinion with you.
Well, I am not at all at fault. Well, because with the permission of the director, I was given appointment as a junior clerk.
Correct.
Well, the only difference is initially they gave me appointment in a class 4 post, and subsequent your lordship may kindly see the comparative list which the inspector has given. If your lordships will permit me to place that.
So, Mr. Swine, I think we've heard you very patiently. Please.
Yes. Annexure 7, your lordship may
kindly
kindly
do all
see.
that, sir. Let us now dictate the order. The challenge in the present petition is to an order dated in March 2005, passed by the Orissa Administrative Tribunal in OA number 237 bracket C of 1995. Sorry, 20th March 1997, passed in OA number 237 bracket C of 1995. Another order dated 16 March 2005, passed in OA number 2315 bracket C of 2004, and a consequential order dated 4 July 2005, passed by the Department of School and Mass Education, Government of Orissa. Paragraph. Mr. Swine, learned counsel petitioner repeatedly urged before the court that he was challenging the above orders in matters to which the petitioner was not a party, only because of certain observations therein, which according to him are prejudicial to the petitioner. Full stop. Paragraph. The petitioner got appointed in a class 4 post in the government on the death of his father under the Rehabilitation Assistance Program. Subsequently, he got further promoted as to a class 3 post. Paragraph. In another unrelated matter by some other person, observation was made by the OAT in its order dated 16 March 2005 to the effect that the department should examine similar appointments of persons initially made in a class 4 post and who were further promoted by examining the legality of the same and terminating such appointments, open quotation, after giving them an opportunity to show cause, so that the applicant and others similarly situated will not have such a grievance, unquote. The above observation was obviously not directed at any individual, including the present petitioner. To stop the consequential order dated 4th July 2005, passed by the department, was equally innocuous. It was a general direction to the inspector of schools, to the director, secondary education, requesting it, open quotation, to kindly terminate the illegal appointments in the class 3 posts by the inspector of schools, Ganjam, after giving them opportunity to show cause in the matter under intimation to this department immediately, unquote. Apprehending that the above direction would adversely affect him, the petitioner rushed to this court with the present petition, in which on 5th September 2005, this court directed status quo as regards the services to be maintained. Paragraph. That stay order has continued for well over 16 years. To stop, the petitioner was around 42 years old when he approached this court, and today there's 1 year left for his retirement. Stop. Not only has he continued in the post, but as was repeatedly pointed out by Mr. Swine, he has got further promotions to the posts of senior clerk and head clerk. Stop. Paragraph. What was essentially an innocuous observation by the tribunal and a consequential order by the government has therefore not been able to be given effect to in the petitioner's case. In other words, not even a show cause notice could be issued to him because of the stay order passed by this court. Paragraph. The court sees no reason why this petition should have been entertained in the first place, much less a stay order granted. Full stop. All the contentions of the petitioner could have been permitted to be advanced in reply to the show cause notice, and as all his further contentions reserved if such order went against him at the stage of challenge by him to such order, which is what is ordered right now while vacating the stay order and dismissing the writ petition. It is so ordered. Yes.
Item number 12.
My presence. May I pray one thing? Your Lordship may grant me liberty in the event any adverse.
No. The whole observation is that only, sir. Yes.
Then Your Lordship may, instead of using the expression dismissal, Your Lordship may say disposed of.
We'll see that. Yeah.
My Lord, Your Lordship, Your Lordship may kindly indicate disposed of.
Yes. What are you saying, sir?
Lord, kindly excuse me to make a mention. My Lord friend,
say you just see, this is a free country.
We are requesting that please get
that
up.
Is all right, sir. It is for the bar to decide these things.
In the dress, it
see
is
what we could do as a court on the judicial side, we have done. It is for the
Item number 12, WPC
Item
14164 of 2006.
My names also, my assistant name may be deleted.
Which one, sir?
Item 12.
I am the respondent.
My learned friend has appeared after.
But I am for the respondent, my lord. Aditya Das for the respondent.
All right. All right. Item 12, who's for the petitioner? None appears for the petitioner. Dismissed for non-prosecution. Okay.
Obliged.
Item number 13. Item number 13, WPC 3182 of 2007.
Here, my lord,
None appears.
I am for the department. Assessment order is under check.
All right. None appears. Dismissed for non-prosecution.
Item number 14.
In this case,
You'll have to speak louder, sir.
in this case, the petitioner has challenged the award passed by OP number 4 of this writ petition on the ground that the issue has not been properly answered.
All right.
First of all, I want to draw my lord's attention that the petitioner was first appointed, was engaged as a daily laborer with effect from 11/11/1997 under the MCL management.
Yes.
Thereafter, in separate branches, he has worked as daily laborer.
Yes.
Lastly, he was engaged as a caddy under the Bosundara Gold Club and worked till 28/10/2000. And also, he was issued with the payslip for the entire entire period. That is from 1997 to October 2000, which is under Annexure 1. He being a commerce graduate, he represented the management to appoint him with a befitting post according to his qualification. It was his mistake, so to say. The management, what he did, the management referred the matter to the union government, who finally referred the matter to the Minister for Adjudication. For adjudicate,
So he did not even apply for a post. Why will he get appointed?
Well, he has not applied. He has only represented the management for
No, where's the question, sir? You can't simply get made a representation to a public sector undertaking and get appointment. What is the system of recruitment? I don't understand. Which public sector undertaking, on the basis of a representation, you get appointment?
It could have been asked.
Sir, tell us
management
this.
could have told him.
No. What does that management has to tell you? Suppose you make a representation to the government of India. Government of India will appoint you on representation.
No.
Then they should tell you, is it? Please apply, sir, whenever there's an advertisement issued.
No, in fact, the petitioner has not appeared in any selection process.
Then where's the question of any mandamus to appoint him?
But his retracement without following the due procedure has also been challenged.
Where is it? Which is that issue, sir?
Because he has already worked.
There are three issues before the Labour Code. Come to page 24, running page 24.
24, my lord. Issues. My lord. Whether the reference is maintainable against MCL, whether the action of the management in determining the service of Sri Siddharth Sabrai with effect from 28/10/2000 was working as a caddy in the Vasundhara Gold Club under the management of MCL is legal and justified. If not, to what relief the workman is entitled to.
So you are working as a caddy in this Vasundhara Golf Club.
My lord.
Did you make them a party?
My lord, I have answered it. As because Vasundhara Gold Club is an unit of the management and is being managed by the management, and the management is made a party.
Okay.
So it is not necessary. I think it is not necessary to make
you can think many things. Your thinking was wrong.
No, my lord.
Yes.
As because the management has referred the matter for adjudication, and management is a party, and management has returned the petitioner from service.
You are engaged as a caddy on a daily wage basis. That's the point.
My lord.
Yes. Yes, nothing wrong in this, sir.
But so not implementing the Vasundhara Club talk.
So the club is run by the officers working in Mahanadi coal fields. They are contributing, they're running the club. The club engaged you as a daily wager to be a caddy.
And also the...
So the club is a separate entity, sir. You have to make them a party.
But it is under the management of MCL.
No, yes. You're not under the employment of MCL, sir. It's very different.
But if not, then how the management could have returned the...
It's the other way around, sir. You should have definitely made the golf club a party. It's a club engaging people. It's like an association of persons, right?
So I am permitted to make him party.
What do you want to do?
I am permitted to implement him as party. I am permitted to implement him as party.
Not now, sir. This is litigation started long ago. Not now.
But still now he is 45 years old.
No. You say
he is a commerce graduate, the ST.
But that's good, sir. He has to wait for his turn, look for some other employment. The challenge, the present petition is to an award dated 17 July 2005.
If at all the golf club is a national party, then the management could have also done this. Because it is under that.
So you are the claimant. Why will the management do it, sir? They are not so charitable. You want employment, you are the claimant, you have to make out your case.
Because the management has referred the matter to the for adjudication.
So they should not even have done that. You have to discharge your burden, sir. Nobody is going to come to your help. Challenge this petition is to an award dated 17 July 2005.
Number 3.
Industry dispute case number 2 of 2003. The case of the petitioner, at whose instance the reference was made to the labor court, was working as a caddy in the Vasundhara Golf Club. Purportedly between 1st November 1997 to 28th October 2000. Aggrieved by the action of the golf club in terminating his services with effect from 28th October 2000, he initiated a labor dispute which was then referred to the labor court for adjudication. Full stop. Among the issues referred was one relating to the legality of the termination of the petitioner's service. Stop. This was answered against the petitioner workman by the labor court on the short ground that the Vasundhara Golf Club was a separate entity and that it had not been made a party to the dispute. The plea of the petitioner that the golf club was under the management of Mahanadi Coalfields Limited, MCL, and therefore it was not necessary to make the golf club separately a party, was not accepted by the labor court. Full stop. The finding on fact was that in terms of the golf club's bylaws, it was operating with a grant received from the management of MCL, and it was running with the aid of the contribution made by the officers of MCL, who were its members. Stop. The finding that, open quotation, the business of the club is totally different from the activities of the management, and that it is not being centrally managed by the management, unquote, has not been able to be refuted by the petitioner workman. Stop. Paragraph. At this stage, a weak attempt was made by counsel of the petitioner that he should at this stage be permitted to implead MCL as a party. Full stop. The court is unable to accept the above submission. This dispute, which began in the year 2000, that is more than 22 years ago, was in fact pending in this court for over 16 years now. And during this entire period, the petitioner has not thought to plead MCL as a party. Full stop. The court does not propose to permit him to do so. at this stage. Paragraph. The petitioner was unable to show. The petitioner is also on merits, unable to place material to counter the case of the opposite parties that he had engaged. He was engaged by the golf club as a caddy boy just for 3 months between July and September 2000 on daily wage basis. So stop. The question of therefore granting any substantial relief that on the basis of his academic qualification, he should be given regular employment at the MCL could obviously not be accepted. So the Labour Court has rightly observed that the petitioner never even applied for a job in MCL. And so the question of giving any such direction simply did not arise. Paragraph. Having heard learned counsel for the petitioner, the court is not satisfied that any ground has been made out for interference. The petition is dismissed.
My lord, 1 minute. My lord, 1 minute. My lord, the petitioner was engaged.
Sir, I have dictated. We have heard you. We have dictated the order. We just finished dictating the orders.
Item 15.
May it please Lordships. My lord, the petitioner here challenges the order passed by the district labor officer under Annexure 4 at page 19. The district labor officer are directed to pay the bonus. Lordships, kindly see page 19, 19. The directed us to pay the bonus, which is not within his jurisdiction, and bonus is also not a part of the wages. It is not coming with the meaning of wages as per the bonus payment of bonus act as well as the other acts, my lord. Lordships, kindly see the 19, page 19, my lord, second para. And that since the said contractors failed to make payment of minimum bonus for the year 2004-2005, which is a well-defined wage under the Contract Labour Regulation Act, we are therefore intimated here to dispose of your liability under 21(4) of the Contract Labour Regulation and Abolition Act by making payment of wages, payment of minimum bonus.
You say minimum bonus is under the Payment of Bonus Act.
No, payment of bonus act, right? You also kindly say payment of bonus act. And
no counter has been filed.
No counter has been filed.
Counter has not been filed, but my lord, Lakshmi, kindly see here after my lord, there's an amendment of Industrial Dispute Amendment Act 2010, which came in effect from 15/9/2010, my lord. There's a change of appropriate government, my lord. Here the file has been transferred.
No, but all this is of 2007, sir.
Yes,
that is only a prospective effect.
No, it's only pending before the Deputy Chief Labour Commissioner now at present.
Whatever it is, how could such a direction be issued? The challenge in the present petition is a direction contained in a letter dated 27 January 2007 of the Assistant Labour Commissioner Anugul that minimum bonus should be paid to all contract laborers who work for more than 30 days under 2004 during 2004-05. So as rightly pointed out by Mr. Manoj Mishra and its senior counsel appearing for the petitioner, the terms and conditions of engagement of contract laborers was governed by the Contract Labour Regulation and Abolition Act 1970, whereas the payment of bonus is regulated by the Payment of Bonus Act. So the question of issuing directions regarding payment of minimum bonus to contract laborers could not have been issued under the CL-R&A Act, which was entirely outside the jurisdiction of the, and the issue of payment of bonus was entirely outside the jurisdiction of the Assistant Labour Commissioner. Full stop. It may be noted here that while issuing notice in the present petition on 26 August 2007, this court had stayed the operation of the impugned order. That interim order has continued since. Till date, no reply has been filed by the state government, despite notice. The illegality of the order is writ large on it. Stop. While exercising his powers under the CL-R&A Act, such a direction for payment of bonus could not have been issued by the Assistant Labour Commissioner, since that was within the realm of the Payment of Bonus Act, which was under the jurisdiction of another officer. Consequently, the directions contained in the impugned communication dated 27 January 2007 is hereby quashed. The repetition is allowed. No order is to cause.
Deeply obliged. Open, my lord. As far as the state is concerned, it may be kept open to pursue as per our remedies.
So that's a later development. This has nothing to do with 2007.
Item 16.
Lordship, in item number 16, file has been misplaced, Your Lordship. Sometime.
Concept of the petitioner states that his file has been misplaced. As and when he is able to locate the file, he can apply to this court to revive the petition. It is dismissed as such.
Item number 17.
We have no instruction.
Counsel, the petitioner states he has no instruction. Dismissed.
Item number 18.
Item 17.
Item 18. W8206 of 2008.
So you have to see weekly, special weekly, all that.
May I audible, my lord? I may pardon, my lord. Item 17, my lord.
So what is the writ petition number, sir? What is the writ petition number?
8321 2020, my lord.
Sir, you're in the wrong list, sir. We are now in the special weekly list.
Special weekly list, item number 18 now. W8206 of 2008.
None appears for the appellant. Dismiss for non-prosecution.
Special weekly list, item number 19. Item number 19, WPC 1840 of 2008.
I am for the OP number 2.
None appears. Dismiss for non-prosecution.
Special weekly list, item number 20.
My lords, I am, may it please your lordships, I am appearing for the petitioner, but I am greatly handicapped. I have instructions and I have not been given the brief. So I pray only 1 day's time.
Why don't you take it and see what it is, sir? These are all very old matters. We'll pass it over. Just borrow the court's paper.
Can it be taken up after recess, my lords?
Yes, yes. Pass over.
Union of India is appearing, my lords.
Item number 21. Special weekly list, item number 21.
Instruction, my lord.
No instructions.
The petitioner may given liberty to
No, not such an old matter. Yes.
Special weekly list, item 22.
May be permitted to withdraw, my lord.
Counsel, the petitioner seeks leave to withdraw this petition. Dismisses withdrawal.
Special weekly list, item 23.
My lords, I will come after recess.
Yes, please. Yes,
and I may be permitted to go through the paper.
Yes, that's why it has been given to you, sir. Here itself.
Oblige.
Special weekly list, item number 23.
None appears. Dismissed for non-prosecution.
Special weekly list, item number 24.
My lord. My lord, item number 24.
24, sir. What is your writ petition number?
The number is WPC number 8271.
Yes. Tell us what the matter is about, sir.
Lord, this is a PIL filed by the sitting MLA for reconstruction repairing of mines area in Sundargarh, my lord.
Sir, is he still sitting?
Yes, my lord.
I see. Has anything changed in the last 14 years, sir?
My lord, actually, we don't have the present report, my lord.
Sorry?
My lord, we don't have the present status report.
So whenever you gather that, sir, you can file a fresh petition. All right.
My lord.
Yes. Now we have many more avenues, sir. If it is pollution, you go to the Pollution Control Board. If it is corruption, you go to the Lokayog. Right?
Already that
you have a bouquet of remedies now. This is by a sitting MLA who approached this court way back in 2008 about non-repair renovation reconstruction of a road for about 60 kilometers from Koira to Bonai via Tensa and Kalaiposh, as well as a road from Koira to Rajamunda via Kalta and NH215 located in Kyonjar, Sundargarh, located in the Sundargarh district. Counsel, the petitioner very frankly states that he is not aware of what are the developments on the issue raised in the petition in the last 14 years. It is accordingly directed that it will be open to the petitioner after ascertaining the current status to seek appropriate remedies as may be available to him in accordance with law. disposed of in the above.
I am for the opposite party sale. Still
All right.
also.
All right.
Union opinion appearance will be noted also.
All right, sir.
Special local list item 25.
May I please your lordship?
Yes, please.
This case, I am practically handicapped in this case, because this CSO come district manager, my lord, who was filed this case in the capacity of then officer, he is died, my lord. So I file a fresh affidavit, and my lord, that apart, my lord, this file also. So
Very good, sir. Very good. We'll note all that, sir.
No, your lordship, kindly see. The cause of action survives, my lord. I am filing a petition, my lord, by him, my lord, next week. And your lordship may kindly put up this case along with WPC.
So whenever that comes up, we'll deal with that. We'll deal with this here now.
Title, my lord, WPC.
It's all right. We're not adjourning this, sir. Counsel to the petitioner states that the person who filed the petition himself is no more, and even his file is not available.
No, my
lord.
No, I don't pay. This matter may be along with that tomorrow.
No, sir. No.
Order was granted in my favor. Stay was given in that other case, my lord. So it is necessary, my lord, because otherwise, my lord, the government funds, government money, he will never pay. It is a due by of the government, civil supply corporation, my lord.
Right.
And your lordship, in the other case, my lord, 3430.
Whenever that comes up, we'll deal with it, sir. Yes.
Pardon?
Item special local list item 26.
Well, I am for the opposite party in this case.
None appears. Dismissal not possible.
Not my name may be reflected.
All right.
SC Das.
Special local list item 27.
No instruction, your
All
lordship.
right. Counsel the petitioner states he has no instructions. Dismissed.
But your lordship, I give the liberty.
I don't to mention my item.
No, sir. No liberty. It's a 2008 matter. Yes.
This is status quo operating, your lordship. In case
That's all right.
Special local list item 28.
Item number 28 state is the petitioner, my lord, challenging the impugned order at Annexure 1 passed by the Commissioner of Land Records. It's a very peculiar case, your lordship will find. The impugned order was passed against the private opposite party number 1, who was admittedly working in Tahsil office of Jagatsinghpur, where the suit land is located.
Has he been served, sir?
Kind permission. Here the contesting opposite party, I just contacted the opposite party. I am appearing. I only pray 1 week brother because he has passed away, my lord. And due to
what remains? What remains? We'll leave the questions open then.
No, my lord.
Here only difficulty because a huge substantive right of the party is involved. So I was praying for only 2-3 days brother, but the party is supposed to come today. Yesterday only I contacted, and he has passed away. This Basant Kumar Mahapatra has passed away.
No. If he has passed away, what is the relief granted to him?
No, if the writ petition is allowed, then I may suffer. My
no,
lord,
no. Suppose we want to dismiss the writ petition, will you prevent us, sir?
No, my lord.
No. I'm seriously asking because some lawyers prevent us from lawyers for the opposite parties prevent us from dismissing a writ petition.
I will never submit that, my lord.
So first, let us understand what the petition is about and whether we want to interfere.
Yes.
My
lord, may kindly look to the writ petition at page 5.
Yes.
Second para, page 5, second para. The opposite party number 1 claims his right basing on unregistered plane. This is a case of Hatpata story, your lordship, from ex-intermediary. There is no rent receipt, there is no ekpadia, there is no tenant's ledger. Purported to have been issued by the ex-intermediary sometimes in 1940 in respect of the land in question. This ascertainment claim of the opposite party is false, frivolous, and fictitious in nature. This deponent submits that the opposite party 1 was an employee in the Tahsil office of Jagatsinghpur, and his service book was opened and maintained by the appropriate authority in due discharge of the official duty. The perusal of the service book, which has not yet been disputed by the opinion 1, reveals that his date of birth is 10/3/1941. So prior to his birth, Hattapata was purportedly issued by the ex-intermediary.
What is the relief granted? Just come to page 17.
Yes, page 17. The commissioner has accepted the Hattapata and
no. Just read that paragraph. Operative portion. Page 17.
17. That your lordship is saying that it has been remanded and to
let's read it, sir. We'll try.
The revisions are allowed subject to verification of the case records in the order passed in OEA case number 1 so in favor of the petitioner, and to check that some order
the same order
was not set aside by the competent court. The Tahsildar should make a Sabik Hal correlation of the lands area with specific portion of the leased plot, with suit hull plot, and if it tallies with the corresponding hull plot, be recorded in favor of the petitioner. The Tahsildar Jagatsinghpur should correct.
So he has to do so many things. It's not automatic.
But this point was not, your lordship may grant liberty to us to raise this point before this particular point. The fraud has been played by the.
All right. The challenge in the present petition is to an order dated 20 January 1993, passed by the Commissioner Land Records and Settlement in RP case number 655 or 58. What is the case number, sir? 658 of 1990.
658 of 90, your lordship.
Right. Paragraph. The above petition has been filed by the opposite predecessor in interest of the opposite party, bracket, who incidentally has since expired, bracket, under section 15 bracket B of the Orissa Survey and Settlement Act 1958 against the recording of the Hull ROR Khata number 201 AC 0.70 decimal and Hull plot 186 AC number 0.50 decimal. And Hull ROR Khata 199 Hull plot 184 AC 0.30 decimal. Full stop. It is seen that the operative portion of the impugned order only requires the authorities to undertake a verification of the case records in an order passed in OEA case number 8644 of 1976 in favor of the opposite party, and to check that it has not been set aside by a competent court. Stop. Tahsildar was asked to make a subic hull correlation of the leased area with specific portion of the leased plot with the suit hull plot, and only if it tallied, then the corresponding hull plot was asked to be recorded in favor of the opposite party. Paragraph. It is thus seen that the impugned order itself was a conditional one, contingent upon the authorities being satisfied on several aspects referred to above. Paragraph. Leaving it open to the petitioner.
My lord, may kindly record my submission that paragraph which I have noted. This fraud has been played by the opposite party number 1.
Yeah.
That may be taken into account by the concerned authority at the time
It will
of.
be open to the state to question the right of the opposite party at the stage of recording of any ROR in his favor. All the contentions raised in the present petition are left open to be urged at that stage. The petition is disposed of.
Special weekly list, item number 29.
Obliged.
None appears dismissed non prosecution.
Special weekly list, item number 30.
None appears dismissed non prosecution.
Special weekly list, item number
I am
31.
appearing for the respondent, my lord. That will be
All right, sir. All right, sir.
Special weekly item number 31.
None appears dismissed non prosecution.
Special weekly list, item 32.
No instruction. Counsel the petitioner states yes, no instructions. Disposed of research.
Special weekly list, item number 33.
None appears dismissed non prosecution.
Special weekly list, item number 34.
None appears dismissed non prosecution.
Special weekly list, item number 35.
May I please, my lords?
Yes.
Land acquisition matter, my lords. My humble prayer would be if your lordship would kindly dispose of this writ petition, permitting the petitioner to raise his grievances before the collector as per the 2013 Act. My lords.
All right. Counsel the petitioner seeks leave to withdraw the petition with liberty to urge the grievances before the authorities under the 2013 Act.
The right to fair compensation. The right to fair compensation transmission.
No, that's okay. Disposed of is withdrawn with liberty paid. All right.
Special weekly item number 36.
Greatly obliged.
36, my lord, no instructions. No instructions. Disposed of is.
Special weekly list, item 37.
Item 37, my lords, MAT case has already been disposed of.
All right.
In view of that, the present writ petition may become infructuous.
Counsel the petitioner states that petition has been rendered infructuous. It is disposed of.
Special weekly list, item 38.
None appears dismissed non prosecution.
Special Legal List item 39.
May I please, Your Lordship?
Yes, please.
My lord, here an ex parte order was passed against the present petitioner. I filed an application under Order 9, Rule 13, that is under Annexure 1. The authorities rejected on the ground that there is a delay of 3 years in presenting the application.
What was the explanation with the delay, sir?
My lord, I had filed an application that it was not within my knowledge. I had not been given an opportunity of hearing. No notice was served to me. These were my grounds.
No, delay.
Delay, my lord, after coming to knowledge that there is an ex parte order, then only I filed an application. I had never noticed.
Let us come to the impugned order. Let us see.
Yes, ma'am. The impugned order is Annexure 1. It starts from page 8. 27/11/2009.
No, this was not non-appearance, sir. Failed to file WS.
My lord, the lawyer did not appear.
That's right. Whatever.
My lord, lawyer did not appear. This was my...
No. Failed to file written statement.
Yes, on perusal of the order sheets in OA number such and such, I found that the petitioner appeal through appeared, it should be, through his advocate on 30/10/2005. During this period, though several adjournments were given to the present petitioner, he did not file his WS. Accordingly, the case was decided ex parte. The present petitioner, after lapse of 3 years, filed the miscase.
You
the
can't
grounds
be
of
unaware, therefore. When you fail to file a written statement, you can't claim I'm unaware what is going to happen in the case.
My lord, it's a mistake of the lawyer.
No, not so long. Even the client has to follow up, sir. You said the challenge of present petition is to an order dated 27th November 2009, passed by the Assistant Commissioner of Endowments in Miss Case number 3 of 2009, arising out of OA number 9 of 2003, which was a proceeding under Section 68 of the Orissa Hindu Religious Endowments Act, bracket OHRE Act, bracket. The petitioner was aggrieved by the original application of the opposite party being decided against him, ex parte, by an order dated.
The ex parte order was, my lord, at Annexure 2,
19th May 2006. However, he filed the application to set aside that ex parte order nearly 3 years later under Section 5 of the Limitation Act. By the impugned order, the Assistant Commissioner has declined to condone the delay of over 3 years in filing such a set-aside application. Paragraph: having heard Mr. Bose, learned counsel, the petitioner, and having produced the impugned order, the court is not satisfied that it suffers from any legal infirmity requiring interference. Indeed, the explanation offered for the inordinate delay of 3 years was extremely weak and unconvincing. The petitioner's lawyer had failed to file the written statement within time, and the petitioner had accordingly been set ex parte. He could not claim to be unaware of that consequence for waiting for over 3 years. No grounds have been made out for interference. The petition is dismissed.
Special Legal List item 40.
40, well, it's no instruction. No instructions.
Special Legal List item 41.
41, Your Lordships, I appear in the second matter.
All right. First, who's in the first?
In fact, in past matter, we were appearing, and this being transferred to my lord senior, he is appearing.
My lord, in this case, I have already filed the consent vakalatam on 15/3/2021. Today morning, I got to know about this case. My
All
name
right,
doesn't
sir.
appear. That is the problem, man.
That's all right. So you can even borrow the file if you don't have it.
My lord.
You have the file?
Yes, please.
I will pass it over. You can get ready with it. We'll pass it over.
Your lordship may take up the second matter in the meantime.
All right.
Yeah, Your Lordships, actually, there's only one very short point of law involved in this matter.
Right.
The advertisement was in way back in 1992, Your Lordships. And both the subordinate services and as well as the OS class 2, OFS class 2, all of them were advertised. Your Lordship, the advertisement is at Annexure 1. Annexure 1, page 14, Your Lordships. At that very moment, Your Lordships, there was no reservation for the woman category. The advertisement itself clearly shows the reservations were only limited to SC, ST, and sports person. There was no reservation for the woman category. Your Lordships, but when the select list came out, it was found, Your Lordships, that the woman category reservation was implemented. So therefore, what happened is, Your Lordships, had that not been done, I probably
Is there an interim order here? Is there an interim order here?
Yeah, interim order has been that you all these
subject to the result.
Result, Your Lordships.
So
I have been appointed, Your Lordships. Today, presently, I'm working on the Orissa Subordinate Finance Service. Had this reservation not applied, then I probably would have gone OFS class 2. And the advertisement itself allowed that you would be appointed subject to your preference and merit. So my preference could not be given effective because suddenly midway this reservation principle was made applicable. And so therefore the short point of law is that if it was not reflected in an advertisement.
No, today what will happen, you'll get your, you get a seniority, is it? If you
get a seniority, maybe a
so there's no guarantee that you would have got selected even if the reservation was not there. What's the guarantee?
Yeah, the merit, without the woman candidate, my merit position would have gone up. Because I'm already...
There's no guarantee you would have got appointed.
No, I mean, I did not get appointed in OFS class 2 is only because of the reservation, because the posts went down for us. That's all, Your Lordship. In fact, the only question of law here is that if the reservation policy was not made applicable in the advertisement, they could have done it subsequently. That's all the point. And I lean upon those Supreme Court judgments saying that, midway you cannot change the criteria. So the rules of the games can't be changed midway. That's a short question of law. And the tribunal, however, of course, dismissed our application on this ground that there was a executive instructions, which was, this advertisement was on 31st December 1992, but there was an executive instructions on 23rd December 1992 for reservation, but that had not been reflected in the advertisement.
Why should they suffer? The people who've got the benefit of it need not suffer then. That's the real problem. And how many of them have got appointed? Several of them, some 5 to 17 or something.
Yes, right? we have. I'm added them as a party. At least, Your Lordship, 5 to around 10 of them, almost 10, 12 of them. Yeah. I'm not asking them to be removed, but I can as well be considered to be fit into the OFS.
Anyway, you got appointed the very next selection, is it?
No, I got appointed in the very selection, Your Lordship.
The same selection?
Same selection, but in the Odisha Your Lordship, look at Annex 6 of my writ. That shows all the posts which were advertised. I got selected in Odisha Subordinate Finance Service, and had this reservation not been applied, I would have gone up. My merit position would have been much above. And that would have enabled me to get in OFS class 2, which is a higher service.
What is your age now? It's a 1992 advertisement, right?
Lordships. I'm 57.
Correct, which means only 3 years left. It will cause enormous difficulty. So what's the reasoning of the OAT?
The OAT said that because there was an executive instruction in place in the very which had come into force on 23rd December 1992 itself, and because the government state in the year 1994 subsequently came up with a rule with a retrospective operation. Therefore, they said that it was a fit case, the reservation could have been allowed. it did not really touch this point that it never reflected in the advertisement and the rules were changed.
Yes.
Paragraph 5, you also can see, paragraph 5 of the impugned order. May I please, ma'am?
Yes, yes.
The Lord Senior Counsel for the applicant, however, submit the Orissa Civil Service Reservation of Vacancies for Women in Public Service Rule 1994 was notified on 31/3/1994 and the same was published in the Orissa Gazette Extraordinary at 8/8/1994. By this rule, the reservation for women became operational retrospectively with effect from 31/12/1992, stipulating clearly that the provision of these rules framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India shall have overriding effect, notwithstanding anything contrary to any other recruitment rule. We do not think there is any bar to retrospective operation of a rule in as much as that could be a policy initiative of the government to correct the imbalance or rectify the wrong that might have been warranted in the intervening period. In regard to the argument of the Lord Senior Counsel that the respondents are bound to recruit as per the advertisement and cannot interpole into the advertisement a view or a stipulation on a later date, the Lord Government Advocate argues that the last date of receipt of the applications was 15/2/1993, and by that time the notification had already come into force. And as there was no statutory violation and a policy direction was to be implemented, there is no reason why the select list should be tinkered with or it should be interfered with. We find merit in the submission of the Law and Government Advocate in as much as the ground of retrospective.
So this law providing for reservation came in 94.
94, but with a
retrospective effect.
Yes.
Yes, yes.
That kindly see the counter affidavit which you have filed. The entire thing which we have stated in the counter that has not been taken into consideration. May I please, because since I don't have the record in the second case, you will also kindly see the first writ petition, page 76. That's the counter affidavit which was filed before the Land Tribunal. So there we have stated in paragraph 6 that much before the last date of submission of application, we came out with a corrigendum indicating the reservation as far as women is concerned.
No, what was the date of the corrigendum?
That
23rd December
92.
92, that was an executive instruction. They came up that,
12/2/93.
That in state of Odisha, they would,
12/2/1993.
that in state of Odisha, they would come up with reservation and relevant,
So if before the date of the advertisement, they came up with the corrigendum then?
No, no. Last date of receipt was 15/2/1993 and this corrigendum
came in December.
No, 12/2/1993. That is page 81, running page 81 of the first brief, my lord.
That corrigendum with regard to age relaxation, not.
Since my lord, he is referring to the first case, I may just point out, kindly see the corrigendum that is available at page 82.
Yes.
Here, my lord, nothing regarding the women's reservation. They are only saying age limit is relaxable for 5 years in case of women.
No.
That
the
was the
government
only
had passed a resolution on 23rd December 92,
Yes,
providing for 33% reservation.
That is the notification I am referring to, and that is page 82. There, reservation regarding women was not introduced in that.
Sir, I'm pointing out about the reservation for women on 23/12/92.
Yes, my lord.
You're saying yes to this also.
23/1993, my lord.
Sir, please listen.
Yes, my lord.
You're not listening to what is being put to you.
My lord,
You're just
sorry,
reading
sorry.
whatever you want to read. This is the whole problem.
Because
come to page 2 of the order, impugned order of the CAT, page 24, running page 24. You have another paper book, I think. Mr. Mudali, you come to page 24.
Yes.
This government had passed a resolution on 23/12/92, reserving 33% of vacancies across the board for women candidates.
Yes. On 23/12/1992, reserving 33% of the vacancies across the board for women candidates. This is
So the resolution became effective on 31/12/92 itself.
Yes, 23/12/1992.
This was before the cutoff date for the.
No, previous page you will also can see. Previous page, last 3 lines you will also can see. Advertisement was notified on 31/12/1990.
So before the advertisement itself, this resolution was passed.
There's no dispute on that, Your Lordship.
Only that it was not disclosed in the advertisement. That's all.
Yes, Your Lordship. That's why in the beginning I stated that there's only one question of law. They having not been reflected in the advertisement.
That's all. It's not that they suddenly thought of it and tried to retrospectively. The rules may have come later, but the resolution was already there. You said the short point. This is 2839 of 2010. The challenge of the present petition is to a judgment dated 9th November 2009, passed by the Orissa Administrative Tribunal, Cuttack Bench, Cuttack bracket OAT, dismissing the petitioner's OAS 2607 bracket C of 1998. Paragraph. The petitioner applied for appointment to the Orissa Financial Service -2 bracket OFS 2 and appeared for the Orissa Civil Services Examination of 1992. Full stop. At the time that the advertisement was issued for the said exam, which included recruitment also to the Orissa Subordinate Financial Service bracket OSFS bracket, the advertisement did not mention that 33% of the vacancies would be earmarked for women candidates. According to the petitioner, at the stage of selection, the opposite parties implemented such a reservation, and consequently, the petitioner had to come down in the order of merit and be content with getting appointment to the Orissa, to the OSFS and not OFS 2. Full stop. Paragraph. In the impugned order, the OAT has noticed that the government had already passed a resolution on 23rd December 1992, reserving 33% of the vacancies across the board for women candidates. For some reason, this was not reflected in the advertisement issued. Full stop. Subsequently, the government came up with the Orissa Civil Service bracket reservation of vacancies for women in public services bracket rules 1994 on 31st March 1994, which was given retrospective effect from 31/12/1992. Paragraph. Even without such retrospective effect, since the resolution was already issued on 23rd December 1992, at least 1 week prior to the advertisement, it could not be said that the reservation for women was introduced after the process had begun. Full stop. It cannot be said, therefore, that the petitioner was prejudiced on account of the implementation of such reservation by means of a resolution issued prior to the advertisement itself. Paragraph. The court is unable to find any error in the impugned judgment of this OAT. The writ petition is dismissed. What about the first writ petition?
Same me.
The reason
Third also same. Third also.
All right. In the Civil 2839 of 2010, in the order passed today, the present petition is also dismissed. The other two petitions are also dismissed.
Oh, bless you.
The same reasons.
List item number 42.
In this writ application, petitioner challenge the annexure 4 order dated 26/12/2008 passed by the member of Board of Revenue illegally without considering the case of the petitioner. My lord, in the case of the petitioner, the learned Tahsildar Sukinda settled or recognized the tenancy of the petitioner by the annexure 1 order dated 3/1/83. After 25 years, the learned collector Jajpur filed OEA revision before the member of Board of Revenue by the annexure 4. That is the OEA revision case number 110/2008. The honorable member passed but illegal order. My lord, kindly read the ordering person. That the running page 25. I am allowed to reading. by set aside in the east land, OA collector come Tahsildar Sukinda has exercised the jurisdiction which is not vested in under the provision of a OA Act order passed by the OA collector come Tahsildar Sukinda without jurisdiction is a non-est. A non-est is a void order. It confers no title on the land. Therefore, his order dated 8383 in OA miscase number 1/83 are set aside. In this order also, member board of revenue directed to evicted me. But the Honorable High Court passed his earlier order dated 6/12/2012.
If the
Call
impugned
for the
order was
lower court
passed,
records. My lord?
the impugned order was passed in your absence. That is your case, correct? Is the impugned order passed in your absence?
No, my lord. That is the illegal order.
So it's not that you did not appear.
No, I am not appear, but
No, you have appeared or not appeared.
No, notice not sufficient, lastly sufficient, but LCR Kalfar and honorable member pass order on merit.
No. So come to page 14.
My lord, what page? My lord?
1-4.
Page 1 my lord.
Now, if you find the cause title, below the cause title, it says for the petitioner for opposite party. Both counsel are present.
Cause title so the Ashok Kumar Sadangi advocate, I am Ashok Kumar Sadangi, I am appear before the member board of revenue.
And one Mr. Ratha appeared for the petitioner there. So why did you say it was passed in your absence?
But member board of revenue not regularly functioning. Without any list, case was had. That is not possible to any advocate to appear in date fix.
No, this recording is wrong according to you. There was no sitting of the Board of Revenue on 26th December.
My lord?
Whether there was any sitting on the date fixed or not before passing the order.
The matter was hard.
Date not fixed, cause list it was published, but cause list that time no cause list in online.
The matter was hard. He was directed to file written note of submission. Everything was. And this type of order, your lordship may remember last Friday, Sukinda Tahsil, the lordship has confirmed the order. This Jamidar's Hatapata without any registration and fraudulently without any ekpadia, without any tenant ledger, the Tahsildar has settled the land.
My lord, the learned collector filed revision after 25 years of a settlement. My lord, kindly see Annexure 1. That is a settlement by the Tahsildar. Running page, my lord. Running page, my lord. 8. Order dated 8/3/83. That is a speaking order of the learned Tahsildar Sukinda. This is a very good order. No illegality committed by the Tahsildar Sukinda. My lord, can peruse the order dated 8/3/83. Running page 7, my lord. That is a speaking order of the learned Tahsildar. What order? What mistake is committed in Tahsildar? Learned collector challenge after 25 years. After passing Annexure 1, the learned Tahsildar also.
No, is there any discussion on the delay, sir?
My lord, 25 years delay.
No. Is there any discussion in the impugned order on the delay?
Not discussed, my lord.
Have you raised it?
Only discussed I am a inherent power. I am a so much power. I have set aside. But a member of Board of Revenue has absolutely no authority. Order is appealable.
Who's for the other side? You're there.
I am for that. So far as this delay point is concerned, keeping aside that point.
How can you keep aside, sir? That's the first and foremost is that.
No, because
he's coming after 25 years. Why keep it aside?
When the fraud was detected by the Tahsildar.
Do you actually say that? Where do you say that? Where do you say that? This fraud is one carte blanche thing.
No, the points which.
Where do you say it is a fraud? First of all,
16,
when you're exercising the power, you should have said that.
Page 16 may kindly be the running page 3 of the internal page 3 of the impugned order. Para 8. Peruse the order stated so of OA collector come Tahsildar Sukinda in OA miscase number. So it is a carbon copy impression in which a few blanks have been filled up in ink with the details specific to Tarun Kumar Raut. It is obvious that this is a copy of mass order in which blank spaces have been left for writing details specific.
Same thing again. The same
order
is also
cut and paste with last Friday.
Those orders are cyclostyle. These orders are also cyclostyle.
Yes, the same Tahsildar and the same Tahsildar.
No, it's not same Tahsildar, it's another Tahsildar.
Will examine it again, sir. Tahsildar.
No, Board of Revenue has already set aside the collector's OA collector's order by the impugned order.
No, somebody has to examine the documents he has, no?
The Board of Revenue has examined. He has submitted all the points. He has filed the written note of argument. My learned friend appeared before the Board of Revenue. Everything, your Lordship, it is a exhaustive order. Everything has been taken care of.
May pardon, my lord.
So he has a full innings already there.
May pardon, sir, my lord.
Yes.
My lord, can you see the order dated 6/12/2012 passed by this honorable court? 6/12/2012. The honorable High Court also called for lower court records to produce before this court. Till that, but no order, no records produced by this
what
state.
you convince on merits, sir. We'll talk about the low court records
Merit,
later.
my lord, is full merit. I have cases of full merits.
What?
Because my lord, kindly read, I would to read Annexure 1. That is speaking order of the Tahsildar. Tahsildar
No, you
maintaining
have to,
all legalities.
So you have to point out from the impugned order which is decided against you, what is wrong with it?
Impugned order, my lord, fully wrong, my lord. Without to, what is
Sir,
the legality,
merely
my
saying
lord?
it is completely
First,
wrong.
my lord, impugned order is not a sustainable law. 25 after the collector filed case after 25 years, but the learned member not discuss single page, single line regarding delay, my lord.
What do you say on merits?
Merits, my lord, full merits.
We'll simply say full merits.
Yes, my lord.
We'll suppose we don't agree with you of full
My
merits.
lord, suddenly case was listed.
So that is not merits, argument on merits.
2 days time be granted, I will file a decision.
No.
Suddenly case was listed.
There's no suddenly here, sir.
Case was
Cases are
first
coming
listed
one by one.
after
Weekly
11
list,
years.
advance list is published, no? Advance list is published. Everybody knows we are calling out old matters every day. We'll at the most pass over, sir. You get ready. You come after lunch. Pass over.
Para 22 may kindly impugned order.
Whenever he comes back,
My lord, tomorrow, my lord, tomorrow.
Sorry, sir.
Special weekly list item 43.
None appears dismissed or not.
I am on behalf of the opposition.
Special weekly list item number 44.
None appears dismissed or not.
Special list weekly list item 45.
None appears dismissed or not.
Special weekly list item 46.
My lord, 46, my lord. That the OJLS proceeding 7 provides 3 OJLS Act, my lord. That is the, my lord, that after 14 years, that the delay, that they initiated the so much proceeding, my lord.
What is the matter about, sir?
Matter about, my lord, the order of the ADM is challenged before my lordship, my lord. That is, they cancelled the lease, my lord, without giving any opportunity, my lord. So that's why I am before my lordship.
No, there's no stay order
Annexure, Annexure 2, my lord, page 12.
Order of the year 1987.
How can we interfere with it today, sir? You cannot interfere today with it.
That my lords also several decisions, my lord, also set ahead and also remitted back, keeping in view the order. My lord, in a number of cases, my lord, that the ADM.
You were not heard by the ADM?
No, ma'am.
When the 87 order was passed, you were not heard?
No, no.
My lord, he has para 2, my lord.
My lord, that the
He has filed his written statement.
under 74 rule, that they have also dealt with the order, that is a retrospective operation. That is a prospective operation of rule, my lord. That is, if my lordship will permit that page 20 may I will place. That is specifically stated, my lord, that the person likely to be affected thereby notice is hereby given that said draft be answer taken into consideration on or after 7/12/74. But the lease was granted prior to that in 72. So that's why that is the prospective operation of rule. That is a curtain of decisions in this honorable court also. And my lords also in the last 12 cases, my lord allowed that one of the case I have given the instance before my lords are passing the order and remitted that take a fresh decision on that point.
Should we pass a similar order?
No, my lord, what has happened in this, where there is a buyer, perhaps, for example, A is the lessee, lease has been cancelled, but subsequently A has sold the land to B, but B has not been noticed, and B is the writ petitioner. There your lordship is remanding the matter that the original purchaser has not been.
Bona fide purchaser.
So here I think the petitioner is not a subsequent purchaser who has not been noticed by the court below.
It's a my lord. I have also purchased my lord. That is the so much. That is the legality of the case, my lord.
No, no. What did you purchase? Where is your title deed?
That sale deed is not annexed.
And this matter has been remitted, my lord. Lakshmi, kindly see the last paragraph of the order, my lord. It has been remitted back.
What says that?
Oh, it has already been remitted.
Remitted.
Then why should we interfere, sir?
Yes.
Remitted.
All right. Since the order, impugned order is one of remitting the issue back to the Tahsildar, the court is not inclined to interfere. However, all the contentions of the parties are left open to be urged before the Tahsildar. The petition is disposed of.
This is look at item 47.
Remitting.
This is look list item 47.
None appears dismissed in office.
Self-equal list item 48.
May I please, your lords. Here in this case, my lord, petitioner is the son of the original lessee. And if your lordship turn to that order impugned is annexed to the relevant
similar order. It has been remitted back to the Tahsildar.
Oh, again. Yes. So we're not interfering, sir.
No. Here, my lord, what happened,
87.
the case has been remitted by the instance of the ADM, my lord, Bhubaneswar. The case has been remitted way back in the year 87, my lord. But till today, my lord, they have not proceeded with the case and not even issuing any notice to the present petitioner.
We'll ask you to appear before the ADM.
Yeah, though the petitioner is entitled to get the lease, my lord, that has been confirmed by the ADM. But since there is some material irregularity, the matter has been remitted to the Tahsildar.
Although the order has been remitted, the impugned order remits the matter to the additional district magistrate. Khurda, is it?
Bhubaneswar.
Bhubaneswar.
ADM Bhubaneswar has remitted it to the my lord Tahsildar.
Who in turn remitted to Tahsildar. It is stated that the matter has not made any progress. What is the revision case? 182.
My lord,
WL case has got remitted.
No, that is RC case number 182 of 87.
Yes.
No.
Revision
before the
case
Tahsildar,
number,
sir, that is the ADM's case. Before Tahsildar,
Yes.
it must be WL case.
Yes,
WL case is my lord. Yes, 833 of 77.
833 of 77.
The court directs that on the strength of the present order, the petitioner will appear before the Tahsildar, where
Yes, my lord, by 15th
Jatni, my lord.
March.
Jatni on 21st March 2022. If not already disposed of, WL case number 833 of 1977 will be disposed of after hearing the petitioner and other parties who may be affected. And the reason order should be passed within a period of 3 months thereafter. And
it is not.
Later than 20th June.
If not already concluded.
If not already,
Yes. If not already passed.
Obliged.
No further directions are called for. All contentions of the parties are left open to be urged before the Tahsildar in accordance with law.
Special legal list item number 49.
Item 49, my lordship, I don't have any instruction.
Counsel petitioner states he has no instructions disposed of as such.
Special legal list item 50.
None appears dismissed for non-prosecution. We'll take Passovers at 2 o'clock and we'll call out the other list also. Come back after lunch.
Special weekly list passed over matter item number 20.
My lord,
May it please your lordships. Whatever I have memorized, and I have got a very poor memory, but since your lordship will be annoyed, so in order to assist your lordship, whatever I have
No, let us see what the matter is.
Yes,
We need
yes.
more time. Give it. No problem.
Matter is the petitioner before lordship is a government of Orissa undertaking.
Mm.
It was exporting this chrome ore concentrate, that is powder.
Mm.
It had a plant at Jajpur, Kaliapani, Jajpur.
Mm.
From Jajpur, it was going to Paradip Mellers. This period is 96, 97 to 2001 and 2. There was a loss of ore of 25,015.486 metric ton. My lords may be pleased to, I made a representation and your lordship will see para 10 and 11 of my writ petition. There was a joint verification by the Central Excise authorities and also the petitioners, and they have estimated that para 11 that 25,015 metric ton is the loss of this chrome ore. So by the annexer 7, that is at page 46 to 47, my lords, I have made a representation to the chairman of the Central Excise authorities. Then, my lords, pending that representation, they resorted to section 142(1) of the Customs Act. So, therefore, I approached this court.
No, you approach it a show cause notice stage or a demand stage?
No, my demand also says, I have got...
There was also a show cause notice issued to you.
Show cause notice was issued and I have replied, and also there was a demand, my lords. There was a, therefore, in pursuance to that demand.
No, 1 minute. There was no order passed on the show cause notice.
Order was, that was passed, my lords. That was passed.
No.
And
order was passed. Let's see the counters.
my lords may annexer 5 or 6, my lords. The superintendent Central Excise said that you have to pay. You have to
was
pay.
this demand pursuant to an adjudication order or simply a demand?
No, there was no adjudication, my lords, as it appears from reading the brief. Annexer 6, page 45, my lords may kindly see. Duty demanded and with interest. Annexer 6, page 45, my lords. And then, my lords, page, sorry. Yes, copy of the letter of the, with enclosure, copy of the regarding payment, annexer 6, page 45 is the notice, condemnation of chrome concentration shortfall and payment of duty. Please refer to this letter number so and so. You are once again requested to pay the duty with interest and with interest.
So what obliges them? Suppose you lose stock for various reasons, A, B, C, D. Normally, there's a transit insurance you take, correct? If there's theft, let's say the lorries or train loads of iron ore are being transported. Let's say there is some banditry on the road, on the road. And you lose iron ore stock. So at the time of clearance for export, you are running short of iron ore, right? You will say, I cannot pay this iron ore customs duty on this iron ore.
No.
Then you will say, so you went to the government and said, because I've lost the stock, you must waive this.
Yes.
They did not agree.
No. Another thing is...
No, they did not agree, saying there is no such law, no policy, no principle.
May I say one thing? The Paradip Port has also given us a stockyard. And this is the period between 96 to 2001 and 2. Because of the super cyclone also, and they admit that.
Sir, all these losses, the only question is,
Yes,
Is it obligatory? Yeah. Is it obligatory in law for customs
whether
duty,
it can
excise duty to be waived off? That's the
yes,
question.
waived out or not. That is the thing. And my lords, my humble submission is, I have made a representation to the chairman, and the chairman is till date has not disposed of. That is annexer. Lordship may kindly see my representation.
So this representation route will not work.
No, I know. And
for everything there can't be representation. There has to be some principle. There has to be some law.
That I know, my lord is very much against representation.
Yes, yes.
My lords may kindly see annexer 11, page 52. Page 52.
So you have to write off losses. This is all part of functioning of businesses.
Man, a superintendent asked me.
So other businesses take out insurance. You'll have a flood insurance, fire insurance.
Yes, my lords.
So you have to have transit insurance. There is transport.
That my lords,
goods are transported. There is insurance.
There, my lords, since my lords, kindly excuse me. So far as that transit insurance is concerned, I have not been able to get that instruction. Now, anyhow, my lords, I will not take your lordship's time. My lords may kindly see annexer 11 at page 52 of the general manager of the petitioner company at 52. My lords, 52, 53, annexer 11.
This is all over, sir. This was in 2007.
Yes.
The central government has refused to waive.
Ballots.
You asked them to wait till your request for waiver is considered. Your request for waiver has now been rejected.
Waiver, that has not been rejected by the chairman. That has been rejected by some other authority, not the chairman.
So what is so sacrosanct about chairman?
Chairman Mallards, he is the person who is the delegate under the statute. He delegates further power to the other officers.
No. Which is the power under statute to waive customs duty or excise duty? Is there a sub power vested in the chairman? I don't think so. The power has to be exercised by the government.
Lordship will just take the picture of chairman CBDT under section 119.
No,
he designates of the income under the Income Tax Act. So
that's different. I don't think there is a section which permits waiver of excise duty and customs.
Mallards.
There will be exemption notifications. That is different.
Mallards. In the counter affidavit, also, there is total silence.
No. They have said in the counter that they are not waiving. I'll tell you the paragraph.
Yes.
Paragraph 7, sir.
Paragraph
7 of the counter.
Yes.
The matter was examined by the ministry and informed that it is not possible to accede to the request for waiver of duty. Annexure 15 is the letter.
Page 7, para 7, page 90, na?
Yes. 91, sir. Page 90, running page 91, internal page.
Yes. 90, 91 minutes. Yes. Since I am already in a grinding manners, the attack is very heavy to what I pray, my lords. Lordship may grant me liberty to approach the appeal authorities under the Customs and Appellate Authority to challenge this notice, my lords, that within a period of 15 days.
All right.
That can be done, my lords.
All right.
And I'll move an application for stay of the demand.
Till then, this will continue.
Yes.
All right. The challenge in the present petition. There are 2 petitions, is it?
My lord, same. I think same.
Same. Second is what? It's 2013.
I've been able to read only one. It's such a big brief, my lords. Only in the morning hours, I got the telephonic call to appear. I said that my Lord Chief Justice will not grant any time, but still then they insisted to appear. And therefore, my Lords,
All right. You see, these are two petitions by Orissa Mining Corporation, questioning the demand raised on it by the
Customs Department, Union of India.
By the Assistant Commissioner, Central Excise and Customs and Service Tax, Baleshwar, regarding short payment of customs duties. In the first writ petition, that is writ petition civil 3098 of 2008, the challenge is to a demand notice dated 15th and 27th March 2007. Followed by another letter dated 27 November 2007, informing the petitioner that since its request for waiver of duty on account of loss of probe concentrate during transit has been turned down, it should immediately pay a duty amounting rupees 102,06478. Failing it, action would be taken under section 142 bracket 1 bracket C bracket Roman small 2 of the Customs Act 1962. Paragraph, when the said writ petition civil 3098 of 2008 was listed in this court on 14/3/2008, this court granted a conditional stay of further recovery subject to the petitioner paying a sum of rupees 40 lakhs to the department. Paragraph, the second writ petition civil 14358 of 2013 by OMC is to the demand raised for the subsequent period on 30th March 2012, 9th May 2012, 28th December 2012, and 26th March 2013 of customs duties for the same ground. Here, in this petition, on 25th March 2014, a conditional stay was granted for further recovery, subject to the petition depositing rupees 56 lakhs within a month. Paragraph is Siddharth Rai, learned counsel for the petitioner, confirms that the aforementioned amounts have been paid and the stay order passed is continuing till date. Paragraph. After making submissions for some time, Mr. Rai prayed leave to withdraw these petitions with the liberty to approach the appellate authority against the impugned demands and to pursue them in accordance with law. Paragraph. In view of the above submission, the court directs that if the petitioner files an appeal not later than 4th April 2022 against the aforementioned impugned demand notices, accompanied by an application for continuation of delay, explaining the delay on account of the pendency of the present petitions. Then such application will be considered on its merits by the appellate authority in accordance with law. Subject to the compliance with the above direction, the interim orders passed for this court in the two writ petitions will continue till such time the appellate authority passes appropriate interim orders. The applications for that relief to be filed by the petitioner. The court clarifies it is not expressed any view on merits. The writ petitions are disposed of the above terms.
Let's make grant 2 weeks time to 3 weeks time.
4th April. Till 4th April.
My lords,
Till 4th April I've given.
Much obliged.
Special weekly list on pass over matter. Special weekly list passed over matter item number 42.
My freedom. In this case, petitioner challenged the order annexure 1, that is order dated annexure 4, order dated 26/12/2008, passed by the member of Board of Revenue in OA revision case number 110/2008. The learned collector Jajpur filed this revision after settlement about 25 years above, my lord. In this case,
No, when did you challenge the impugned order?
Impugned order, my lord, it correctly filed as per section 80.
No, what is the date of the 1 minute, sir? What is the date of the impugned order? What is the date of your petition?
My lord, date of impugned order, my lord, that is the order dated 26/12/2008 by the annexure 4.
All right.
Our date of settlement, my lord, that is the order dated 3/1/83 by the annexure 1.
No. 26/12/2008 order.
My lord.
He doesn't understand.
Challenge in 2010.
Impugned order was challenged.
Impugned order was challenged in the year of 2010, my lord. But of the
What is
Board
your
of
explanation with regard to delay in filing the petition challenging the impugned order?
my lord, in the Board of Revenue, the member has no specific date for pronouncement of order. Any date by any motive, pass order. Order reserved, but order reserved for 1 year or 3 years. When I will know,
Not within your.
my lord, my last extradited submission, the ground also mentioned, when the member of Board of Revenue pass order directing the Tahsildar in his last ordering person evicted the petitioner from the case land, that is without jurisdiction, petitioner came to know that the member of Board of Revenue pronounced his order. That ground also I'll come file in mention. When the petitioner eviction notice received from the Tahsildar Sukinda, then petitioner filed, and the honorable court also until protected me. But the collector filed the revision after 25 years. Petitioner is a poor farmer, my lord. Not reading, only writing Odia signature, my lord. But a learned collector filed revision after 25 years. That is, as per the section 81 of the OA Act, that is a deeming provision. Tenants is already accepted by the Revenue Authority. How can the Board of Revenue has a power under section 35B, the cancel my settlement? That is the administrative order. 38B cannot attract in this proceeding, my lord. So order, member Board of Revenue order is divided, my lord.
Yes, Mr. Manti.
My lord, so far as the first point which I want to argue for your lordship, that is, this writ petition is filed after 18 months from the date of order. And there is no explanation as to why what my learned friend is saying. That is no ground in it. Number two is that he was supposed to place some decisions with regard to the merit of the case. That limitation part is there. But my respectful submission is that if your lordship will go through the merit of the case and para
5.
Correct. Limitation part has been discussed. No, there is 5.
Para 5.
Para 5, not para 5.
Para 3 bottom and then para 5.
Yes, para 22 at page 10 of the internal page of the learned advocate for the opposite party has argued that this revision petition is barred by limitation because it has been filed after lapse of 25 years. The issue of period of limitation for initiating the proceeding under section 38B of the OE Act has already been settled by the Honorable Supreme Court in the state of Orissa, Nityananda Satpathy and others reported, and also in state of Orissa, other Brundavan Sharma and others. the legislature has consciously and valid reason not provided any period of limitation for entertaining the revision petition under section 38 because the Board of Revenue has exercised its wisdom in entertaining the revision petition in the facts and circumstances of this case. This is the discussion which and so far as merit of the case, if Lordship will see, everything has been narrated in the impugned order. How the Tahsildar has...
No, but 23 years delay is extraordinary. 25 years is extraordinary.
Pardon me?
25 years delay is
Yes,
extraordinary, isn't it?
And the writ is also filed after 18 months.
So one period of delay doesn't cancel out the other.
My lord, what has happened in Sukinda Tahsil, some unscrupulous Tahsildars, they had nexus with some local people and they had settled this matter on the basis of unregistered Hatpata, etc. without verifying the tenant's ledger or ekpadia. And subsequently it was discovered and the collector has moved because there is no other alternative remedy for the state to get back the valuable land to its originality.
Pardon, my lord.
Yes, sir. What do you say on merits?
My lord, the merits, my lord. My lord, Annexure 2, my lord. That is a rent receipt paid by the petitioner.
So rent receipt will not give you title.
My lord, Annexure 3, my lord. The error also corrected in my favor, my lord. But in the other hand, member board of Revenue has not discussed in his judgment regarding illegality of the order. Only fraud. Fraud decide. Revenue authority has no jurisdiction to decide fraud, my lord. If the question of a fraud arises, the matter is referred to competent civil court.
No.
Because member of
you have to first discharge your burden, sir. You have to first discharge your burden. You did not produce any documents. Just come to the para 3.
My document is absolutely not necessary because LCR received. All the document I am produced before the LCR. Tahsildar admitted. All original records are produced before the Tahsildar Sukinda. LCR received by the member of Board of Revenue. How are the original record available with petitioner, my lord?
All right.
Only Xerox copy available, my lord.
All right.
My respectful submission, my lord, kindly see Annexure 1. The learned Tahsildar discuss his judgment. I produce all the original document, my lord.
All right.
My respectful submission, my lord. The order dated 8/3/83, learned Tahsildar discussed. The petitioner appear and produce all the original documents. Are the original documents also available in the LCR? Member be accepted. Member admitted. The original document available in the LCR. But committed fraud, my lord.
All right.
How can fraud committed, my lord?
All right. Order is reserved, sir. All right.
My lord, I may be permitted to file a decision within 3 to 4 days.
Written submissions be filed within 3 days. All right.
Honorable Court also set aside that type of order only 15 days back.
All right.
That is also covered by this decision. My lord, I may be permitted to file decision within 7 days or 5 days. Obligement.
3 days. 3 days.
3 days. Obligement.
Weekly list. Weekly list, fresh admission, item number 1.
Here the revenue has filed the appeal, and the question is whether the related return filed subsequently revised and can be accepted by the authority or not. The fact of the case is that it is a raid case. Search was conducted.
Isn't this a covered issue? It's not covered by anything.
No, it is prior to amendment. So 139.54, I mean prior to amendment that 139.4, this case has been. You're also, I'm placing two minutes. Search was conducted 9/8/2005. Notice for file return 153A dated 8/3/2006, return filed 28/5/2006, disclosing some amount. Then, my lord, revised return filed 6/12/2007.
Now come to para 6 of the IT-80 order.
Yes. On carefully going through the imping orders of the authorities below and the material made available to the tribunal, the undisputed fact are that for all the years, assessment years under consideration, the assessee filed return on 28/4/2006 in response to the notice under 153A. But after reconsider the entry income investment with the statement of affair, the assessee filed so much revised return 6/12/2007. The issue is not whether if not revised.
Don't
Yes,
stop like
sorry,
this,
sorry.
please read.
Oh, sorry. Disclosing the above additional income before this same was deleted by the tax authority. There is also no dispute of the facts that the assessing officer has utilized the information made by the revised return filed by the assessee. By filing the revised return disclosing additional income in the revised return, the intention of the assessee appear to be very much clear for the voluntary disclosure of the said income, which was claimed by the assessee to have been detected after filing of the original return, but before assessment. Since the assessee has disclosed the income of the investment so moto in the revised return of income filed before the detection of the same by the department, and since the assessing officer has utilized the information made in the revised return, the said amount cannot held to be undisclosed income as rightly controlled by AR of the assessee.
Correct. So before the AO gets to know it, if the assessee himself disclosed it, can't be characterized as undisclosed. As simple as that. This is common sense.
No, I am not. It has. He has
No,
been
no. The
disclosed.
only ground in which you're treating is undisclosed because it was not in the original return.
No, my submission is not that the original return not filed within time. Therefore, whether the revised return be
That's not
accepted.
what you've argued, sir. That's not what you've argued.
Yes, ma'am, that is the issue. Your Lordship.
No. You've not argued that before the IT.
But finding is that.
No, the finding in para 6 is only about whether you can rely on the revised return.
But finding is given somewhere else. I'm just listening. He has quoted the first appellate order. But first appellate enhance the assessment order. Now yes, I'll take you to Lordship, running page 28, paragraph 10, start from the Lord and CIT appeal. The Lord and CIT appeal confirm the same, but the observation that there is no source available of creating or generating of own cash funds so and so. The Lord and AR of the submitted before us that the assessing officer as well the answer has
not that point at all. This is not that point about delayed filing, sir.
But
there is no such point argued or considered.
That is not exactly. Lordship,
No.
Yeah, Lordship, false Lordship, that is not exactly argued.
Yes.
But this issue was discussed in the first appellate authority also. That is the issue before the assessing officer also. Let's kindly see the assessment order.
So we have to go by the IT-80 order. The appeal arises from the IT-80 order.
Yes.
This is an appeal by the department against an order dated 25th April 2012, passed by the Income Tax Appellate Tribunal in ITASS number 96/CTK/2009 for the assessment year 2005-06. Paragraph 1 of the points urged before this court is that the IT-80 was not justified in treating the revised return filed by the SSC pursuant to the notice under section 153 capital A of Income Tax Act 1961, when there is no such provision in the act permitting it. Paragraph, the court finds that in the impugned order of the IT-80, it has been rightly observed that the disclosure made by the SSC in the revised return was in fact relied upon by the assessing officer and the CIT bracket A, and could not be characterized as single quotes undisclosed, unquote, since in any event the disclosure had been made by the SSC prior to the return being picked up for scrutiny. Paragraph, it was then argued that the IT-80 failed to consider the issue of delay in filing the original return itself. The court finds there's no such discussion of any such submission made by the department before the IT-80. The court therefore does not permit the department to raise this contention at this stage. Paragraph, the court finds no error vitiating the impugned order of the IT-80. No substantial question of law arises. The appeal is dismissed.
Weekly list item number 2.
Yeah, item number 2 may pass over, Ms. Chimanka is another.
All right.
Weekly list item number 3.
Three has already been passed. ITA 2 of 2016.
Yeah, in view of the order passed in ITA 2 of 2016, this appeal is
18/12/2019.
Yeah, 18/12/2019. This appeal is dismissed.
Weekly list item number 4.
Here the question, the department framed the question whether the deduction is permissible of earning of interest under Section 56 of the Act. The fact remains that
the consistency, it's gone back to the A only.
But fact remains he's himself claiming deduction of 10% of the total deposit of the claiming 10% of this income from other sources. Whether and the tribunal, he said that his income, this received of interest is prior to production
finds
of the,
that it's that earlier you allowed it in 2008-09.
Yes.
You say the present appeal of the department arises from an order dated 14/2/2013 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack bracket IT-80 in ITA number 460/CTK/2011 for the assessment year bracket AY 2007-08. The issue sought to be urged before this court is whether the IT-80 was justified in allowing claim of 10% of the interest income claimed at section 57 bracket Roman small 3 bracket of the Income Tax Act 1961 bracket Act, when the SSC could not establish that the expenditure was incurred wholly and exclusively for earning interest income, question mark. The court finds that by the impugned order, the IT-80 has merely remanded the matter to the assessing officer with the direction to follow its order for AY 2008-09 in respect to the same SSC, where the issue had been decided in its favor. Paragraph. In other words, the IT-80 is merely requiring the AO to apply the rule of consistency, as already explained by the Supreme Court in Radhaswamy Satsang versus Commissioner of Income Tax and Excel India. We'll give you the citations. Consequently, this court finds no reason to interfere with the impugned order of the IT-80. No substantial question of law arises. The appeal is dismissed.
Weekly list item number 5.
None appears dismissed for non-prosecution.
Weekly list item number 6.
None appears dismissed for non-prosecution.
Weekly list item number 7.
The PIL matter, earlier whether petitioner moved before this honorable court. This honorable court disposed of the PIL under Annex 1 mandate. Kindly similar order should be made to evict the enclosure and direct to approve the construct of the Amendment Center. But till today, the eviction was made, but construction was not made mandate. I made a representation on Annex 3 mandate, take 15.
You have to file a contempt then. Can't file another PIL like this. If the order is not complied, you have to file contempt.
Yeah, under Annex 2, they have directed to alien February government.
Correct. If they did not comply with that, you can't file another writ petition, sir. You have to file a contempt. And you have to file it within time. What is your instruction?
Order has been complied with.
Oh, the Anganwadi center has come up.
No. In the previous writ petition, he has said that eviction is there and private encroachers have encroached upon that land. And the order was to evict them.
Oh.
The said order was complied with. Now he came up before this honorable court with a prayer to
construct an Anganwadi center. Yes.
That instruction we don't have released for the first time.
No, he made a representation. You consider that the petitioner's representation. Have you received it? Yeah. Dated 1st November 2020 shall be considered by the collector Bhadra. And after hearing the petitioner, a reasoned order shall be passed not later than 6 June 2022. A copy of this order be produced by the petitioner before Collector Bhadra not later than 7th March 2022 for compliance. The court clarifies it has not expressed any view in the matter.
Weekly list item number 8.
May I please allow? And the petitioners, those who are working as the Gram Rojgar Sabaks in the Gram Panchayat, state of Orissa, they were appointed under the Mahatma Gandhi National Rural Employment Guarantee Scheme, Act 2005. Under the scheme, they were appointed and they were continuing throughout the state of Orissa. There was no avenue of their promotion. In 2013, an amendment was brought giving a scope for promotion to the post of the DLW. There it was carved that 70% of the will be by direct recruitment, and 30% of this post will be filled up from among the Gram Rojgar Sabaks. Plus Annexure 6, your Lordship may kindly see. That is at page 80. Then in that one, the 70% of the vacancies shall be filled up by the direct recruitment in accordance with Rule 9, and 30% of the vacancies shall be filled up by selection from among the Gram Rojgar Sabaks. And thereafter, to accommodate them further, a further amendment was made to the Rule 8 of the 2008, that in order to eligible for appointment to the service, Gram Rojgar Sabaks must have passed +2 examination or any other examination equivalent thereto, and must have rendered at least 5 years of continuous service as Gram Rojgar Sabak, and minimum skill in computer education shall have to be acquired within a period of 6 months from the date of joining. But that was there, and from 2013 till 2021, all the grams, around 7,000 in the state, they were accommodated. In 2021, on 29th of July, in exercise, that was also the last amendment was brought by way of 309, in exercising the power under Constitution 309. And again, in 2021, in exercise of power 309, they promulgated a rule superseding 2008 rules, where we were accommodated. There, your lordships, they said that the rule is superseded and another rule is implemented, and they call this person.
Who's for the state?
Lord Ms. Patnaik.
You say notice, Ms. Suman Patnaik accepts notice for opposite parties. Every collector has been made party.
Because it's a district level post and any other past is out to lap. That, sir.
What's the point, sir? You can't make every collector a party.
My lord, sir. The state will be
of opposite party number 1, who will represent all the other opposite parties. There's no need, therefore, for notice to go to every collector of every district. Reply be filed within 4 weeks. Rejoinder before the next date. 22nd June.
Weekly list item number 9.
So only thing is that may I privilege equitable order that any appointment made will be subject to result because our 30% they will claim equity thereafter. Any sir.
Let the readings be complete, sir. All right.
Miles. Okay.
Weekly list item number 9.
Let's say the order passed under section 263 is impugned before your lordship, which is appealable in nature. And in fact, I have filed my appeal before the IT at Cuttack. The bench is not functioning, there is vacancy. In the pending that, the assessing authority is continuing to implement that order, making my appeal infructuous. Now that's being the fact that constrained me to bring to come to your lordship. And so on the merit, if you are merit, since 1978, the petitioner society has the registration under section 12A.
1 minute, sir. Where is Mr. Padi?
On behalf of the department.
Mr. Chimanka.
Chimanka is on other court. But in this, it is an appellable order.
No, but he says IT-80 is not functioning.
It will function from 28th February.
So we'll just put it off. We'll see if it functions.
Let's say the assessing authority is actually proceeding ahead. And if it concludes, then my
ahead means what?
Then my proceeding before the ITAD will be rendered infructuous.
What is that proceeding ahead means what? What is
that 143.3 assessment is going at as per the direction.
No order has been passed yet.
No, they are. In fact, I have given them the intimations, but still annexed the notices.
No. Have they passed any demand? We issued any demand notice?
No, the assessment proceeding will be concluded.
That's all right.
But then my challenge to 263 will be infructuous. So what I beg to submit your lordship?
Wait till 7th, sir. If the
what I beg to
you've already filed an appeal.
My lord, what I beg
says IT-80 will start functioning from 28th. So we will keep it for 7th. If it does not, on that day we'll consider. List of 7th
that
March.
period, at least the assessing authority should not complete the assessment.
Saying anything. Sorry.
Or your lordship can observe that any assessment order will be subject to that at least. Because otherwise the entire proceeding, even coming before your lordship, would be infructuous. Kindly mark your lordship. Since 1978, consistently the petitioner has been assessed by granting the exemption under section 11.
Right.
And even after the change of law in 2020, it was extended. The only period it is picked in the assessment year 15-16. I don't stand on the way and I follow the law, but if the assessing authority concludes, then that will be a problem. That is
all right.
Weekly list item number 10.
Lordship keeping it to 7th.
Yes.
In item 10 mil. Here, millets Watco, the opposite part number 2 and 3, is supplying millets water to the Cuttack as well as Mulpuri millet. Though initially millet urban development department was supplying, but in the year 2020, for the first time, Watco came to picture, and Watco is supplying the millets drinking water to the citizen of Cuttack as well as Puri. In one instances, my lord, find I have given a videograph.
Sir, what is there to show you delivered this to Watco?
No, I am not challenging the Lord that portion. I am only.
No. Your representation.
Yes, my representation is at Annex 2, where it was detected in the name of new pipe. They are using second-hand pipe.
All right. You say the petitioner's representation shall be considered by the General Manager, Watco Division, Cuttack. Opposite party number?
3 mal.
And after hearing the petitioner, the reasoned order should be passed not later than 11th April 2022. The court clarifies it is not expressed in the matter. All
right. Orders item number 11.
May pray can opportunity of hearing can
already done. I've said that already.
Orders item number 11.
May I please? Well, here a technical thing is that IA number 12035 of 21, the sole petitioner has died. Your lordship may formally allow this.
Yeah. Tell us what the matter is.
Yes, my lord may kindly turn to page 30 for a moment. A date chart was given in the code below. That will be easier for me to address your lordship. Page 30. My lord, in the year 1980, one Bebandobasta case was instituted by the Tahsildar Padampur, in which the Achyutananda Singh, who is the OP number 5, intervened in the matter. he was asked to file certain documents. He took several adjournments, did not file any documents. Ultimately, he questions the initiation of proceeding against me before an appellate court. The appellate court, your lordship will see, posted on several dates regarding maintenance, because I raised the point of maintainability that the appeal filed by him is not maintainable because the proceeding in the court below has not been culminated. The appeal was posted to several dates for hearing. Ultimately, my lord, when the officer got transferred, he passed an order allowing the appeal. I filed an application for recall. Your lordship will see page 22, that portion. The order, page 21, if your lordship may see, thereafter I can take to page 22.
Yes.
The Tahsildar is directed to divide the case schedule land between Raghuveer Das, Raghuveer Singh and appellants, Snehalata and Sasubhushan Singh, and the share allotted to Raghuveer will again be divided into Raghuveer and Binodini and to dispose of the case as per law. He decides the appeal. I filed an application for recall. That is 29/7/2002 order. He recalled the order and posted the matter for hearing. This was questioned by the private opposite party before the Board of Revenue. The Board of Revenue allowed the appeal, allowed the revision, and set aside the order dated 29/7/2002. The original case, Devandapasta case, was pending.
Now, who's appearing for that other party?
I am appearing for OP number 1. In fact, he has filed an application for review under section 38A. 38A of the OE Act says, my lord, under the statute, my lord, he has a very limited power. Lords, you may see 38A. Any decision made or order passed under this act, whether before or after the commencement of the OEA.
So no power of review, you're saying? No power of review?
No power of review, excepting only arithmetical and clerical error.
Like 151?
52.
52, correct.
So it's not a case of 47(1) or section 114 of the CPC. And besides, he is a statutory authority. He can only draw the power even under the act. So that being no power to review, he having reviewed the order, because recall amounts to rehearing, my lord. It amounts to review of the order. So that means that there being no clerical error and arithmetical error, the court reviewed the order, and accordingly an appeal was filed before the member of Board of Revenue, and member of Board of Revenue said that his order was wrong because he could not have reviewed his own order. So that action, my lord, that one decision, my lord, of this honorable court reported in 54 CLT 515. The two paragraphs, my lord, may yes, ma'am. One is at page 522, para 11.
Yes.
Assuming that OEA collector should not have entertained the claim under section 6 and 7 of the Act on the ground of bar of limitation, we are clearly of the opinion that the order of settlement was not a nullity, in as much as he was competent as regards the nature and the claim to exercise jurisdiction. In review application, the opposite party 1 to 12 did not raise any objection that application under section 6 and 17 were barred by limitation. The OEA collector, while granting the review, did not also record a finding that the application was barred by limitation. The question was for the first time raised before the appellate authority. It was, however, contended by the petitioner before the appellate authority that the application was filed in time, but it was kept pending till 30/10/1963. The appellate authority, however, found that the application was barred by limitation. On the basis of that finding, it is urged in this writ application that the claim under section 6 and 7 of the Act having been filed beyond the period of limitation, the order of settlement is without jurisdiction. We are unable to accede to this contention. The decision on the question of limitation is taken only after the court or tribunal has embarked upon an inquiry. If a decision is taken in a suit proceeding which is barred by time, it is not a nullity. It is an illegality committed in course of exercise of jurisdiction and can only be remedied by an appellate or revisional authority. In Itiar Matai versus Varke and another, their lordship laid down as follows. Even assuming that the suit was barred by time, it is difficult to appreciate the contention of the learned counsel that the decree can be treated as a nullity and ignored the subsequent litigation. If the suit was barred by time and yet the court decreed it, the court would be committing an illegality and therefore the aggrieved parties would be entitled to have the decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction over the subject matter of the suit and over the parties thereto, though bound to decide the right, may decide wrong, and that even though it decided wrong, it would not be doing something which it had no jurisdiction to do. It had the jurisdiction over the subject matter, and it had the jurisdiction over the party, and therefore merely because it made an error in deciding a vital issue in the suit, it cannot be said that it has acted beyond its jurisdiction. As has been often said, the courts have jurisdiction to decide right or to decide wrong, and even though they decide wrong, the decree rendered by them cannot be treated as nullity. Then, my lord, last para 14, my lord. In the middle, my lord.
Yes.
Be that is as it may, your lordship got it?
Yes.
Be that as it may, where a tribunal has jurisdiction to decide a matter, it does not lose its jurisdiction by passing its decision upon an incorrect determination of any question of fact or law. The decision must be regarded as valid so long as it is not set aside or declared invalid by a court of competent jurisdiction. The order of settlement dated 2/4/1966 was not reversed by appeal or revision.
Yes, Mr. Bose.
My lord, may kindly see the order which was impugned before the revisional authority. The case was never posted for hearing. It was posted on hearing of the maintainability. The predecessor, he notes down in the order that my predecessor wrongly passed that of final order when it was never posted for final argument. So I am recalling that order and posting
There
it
is a
for
power
hearing.
to do that is the question, sir.
My lord, he can recall his own mistake. He can recall his own mistake.
These are all tribunals of limited jurisdiction.
My lord, but when a case was never posted for hearing.
Yes, yes. The higher authority will correct it, sir.
My lord,
There is always a remedy. You see the challenge in the present petition.
Then your lordship may say, permit me that I can challenge that in revisional court.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to challenge the judgment dated 29/5/2002.
Yes, madam.
An order dated 29 July 2002, passed in GA Appeal number 2 of 1998. In other proceedings in accordance with law, disposed of is withdrawn with liberty straightforward.
That passed in OEA Appeal number 2 of 98.
Oh, only 2 of 98.
Before the revisional court. Your lordship may formally allow that substitution application.
Yeah, is allowed. All right.
Quick list item of 12.
Demand is more than 1 crore. And question has been framed at page number 6.
Not framed, suggested.
Page 41(1) of the IT Act. The cessation of liability become the added as per the provision of 41(1) of the IT Act. And second is the same 194C. Only 2 grounds are there.
Which one are you reading, sir? You are in ITA 5 of 2013.
Yeah,
125. IT 125 of 2012.
Oh, right. Tell us what is wrong with the impugned order.
Non-deduction of TDS.
No, what is wrong with the impugned order of the IT-18? Para 5.
The paragraph, page 20, paragraph 7. During the course of hearing, the learned DR has vehemently argued that the learned CIT bill is not justified in relating the addition made by the assessing officer on the ground that he does not consider the latest decision on the issue on hand, and the learned CIT bill has admitted additional evidence, being the agreement entered by the assessee with the subcontractor without putting the same to the assessing officer or have to say. Therefore, learned CIT is not justified in relating the addition made by the assessing officer. Then he cited, he relied the decision on Guwahati High Court in the case of Ranjit Kumar Chaudhary versus CIT and Podar Swadesh Udyog Private Limited, and also the decision rendered by the Honorable Gujarat High Court in the case of CIT versus Wali Mohammad Ahmedabad, and in the case of CIT versus.
Come to para 9, sir.
Yes. Then order passed in favor of the petitioner.
SSC. What is wrong with para 9? That's the reasoning.
No, paragraph 9 is correct. Then deduction of 1% TDS.
Then that question goes, sir, if para 9 is correct. All right. The department's appeal is directed against an order dated 25th June 2012 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, in ITA number 266/CTK/2011 for the assessment year 2008-09. Paragraph. One question urged by the department is whether the IT-80 was justified in holding that unless there is a cessation of liability, income cannot be added under section 41(1) of the Act. The contention of the department was that since the assessee had received payments indirectly through credit into the account of its financier, it amounted to a reduction of liability of the assessee. However, the IT-80 has disagreed with the above contention by holding that in terms of the judgment of the Supreme Court in Sagauli Sugar Works Private Limited, 236 ITR 518, and of the Gujarat High Court in CIT versus Silver Cotton Mills Company Limited, 254 ITR 728 Gujarat unless there is a cessation of liability, income cannot be added under section 41(1) of the Act. Full stop. Factually, even on 31/3/2007, the liability owing to Balaji Associates was shown as 1661,281. Full stop. Consequently, the liability had not ceased. Paragraph. Since the entire decision turns purely on facts, court sees no substantial question of law arising. The appeal is dismissed.
Quickly list item 13.
Installer.
Covered.
ITA 2/16.
18/12/2019.
Right.
Item 13.
In ITA 2 of 2016, this appeal is also dismissed.
Sorry. Item 13. 14 is covered.
Oh, that 14 is covered. Now,
Yes.
what is 13?
13 is covered.
13 is. The demand is more than 3 crores. 30. And here the question framed in page number not more. Whether the London IT-80 was justified in reducing the quantum of disallowance, only disallowance of expenditure under that pool labor charges, incentive charges, business promotion,
All
bonus.
factual.
And that has been
the
allowed by the tribunal in paragraph 9.
All right. This present appeal with the department directed against an order dated 31st August 2012 passed by the IT-80 in ITA numbers 89, 90, 91 PTK of 2012 for the assessment years AYs 2006-07, 2007-08 and 2008-09. Among the questions sought to be urged by the department is whether the reduction of the quantum of disallowance by the IT-80 under the heads of single quotes pool labor charges, incentive charges, business promotion, donation, subscription was justified. Question mark. Having heard learned counsel for the department and having produced the impugned order of the IT80, the court finds that the determination of the IT80 on facts. No, determination on these issues turn purely on facts, giving no rise to substantial question of law. The appeal is accordingly dismissed.
Weekly list item number 15.
So the demand is more than 8 crores.
All right.
And question arises at page 4, whether on the facts and circumstances of the case, the learned IT was justified in allowing the claim of the assessee amount to 10 crores 67 lakhs as expenses under the head overburden cutting and removal charges, ignoring the fact that the expenses clearly falls within the scope section 35E of the IT Act. 35E.
Scientific experiment.
Deduction for expenditure on prospecting etc. for certain minerals.
For prospecting.
Where an assessee being an Indian company or a person other than a company who is resident in India or engaged in any operation relating to prospecting for or extraction or production of any minerals or incurs after the 31st day of March 70, any expenditure specified in subsection 2, the assessee shall in accordance with and subject to the provision of this section be allowed for each one of the relevant previous year a deduction of an amount equal to 1/10 of the amount of such expenditure.
This was the department's appeal before the IT80 also.
Yes.
The department is an appeal against the order dated 22nd February 2013, passed by the IT80 in IT number 31/CTK/2013 for the AY 2009-10. The question sought to be urged in the present appeal concerns the allowing the claim of the assessee under the expenses as expenses under the head single quotes overburden cutting and removal charges, unquote. Paragraph. The contention of the department is that such expenses fell within the scope of section 35 capital E of the Act. Having perused the impugned order of the IT80 and having heard counsel for the department, the court is of the view that the issues were decided by the IT80 purely on the basis of facts and on concurring with the CITA. Consequently, the court finds no substantial question of law arising. The appeal is dismissed.
Weekly list item 16.
16, my lord, this is covered your lordship's order 120 IT 120 of 13 that has been disposed upon 18 February, my lord, that has not been admitted of the same.
All right. The reason stated
another
the order dated 18 February 2022 in 120 of 2000.
18, my lord.
ITA number
120 of 13 2013.
The present appeal is also dismissed.
Weekly list item 17.
May I please, the lordship?
Yes.
This is my lord, the petitioner along with the villagers have made grievances regarding the illegal mining, sand mining in the Brahmani river of Vrindavan Balighat. And the concerned opposite part number 3, the Tahsildar, also seized the heavy proclaim machines which are being using as a.
So you should make this representation you made 2911.
That is under Annex 3 before the collector Jajpur.
But what is that to show it's been delivered?
They have not yet decided, my lord. If lordship directed, then we can approach the collector Jajpur.
Oh, the fresh representation.
My lord.
Counsel the petitioner seek leave to withdraw this petition with liberty to make a fresh representation to the authorities in accordance with law. And after following up on such representation to seek appropriate remedies. This post office withdrawn with liberty spread.
Weekly list item 18.
Item number 18, not pressed.
Not pressed. All right. This is not pressed.
Weekly list item 19.
May I please your lordship, my lord? My lord, here the petitioners are challenging the inaction on the part of the opposite party collector and the Tahsildar in removing the encroachment by the opposite party number 3 to 5. Representation under Annexure 2 has been given is pending since 21/5/2021, my lord.
these three people have encroached the land and they are unable to take their vehicle to their houses, and they are only going by walking to their house, my lord. Village road has been completely, my lord, encroached, my lord. Annexure 2 is the, my lord, representation to the collector
All right.
and
Petitioner's
Tahsildar.
representation shall be examined by the collector and after issue notice to the petitioner, as well as opposite parties 2 to 5.
3 to 5.
2 is some Jyoti Ranjan Swine. Oh,
2 is Tahsildar.
right, 3 to
Dakshi.
5. Correct. 3 to 5. And after giving them a hearing, pass the regional order not later than 12th April 2022 and communicated to the petitioners to the parties within a week thereof. If agreed to be open to the parties to seek appropriate remedies in accordance with law, the court clarifies it has not expressed any viewpoints.
Vehicle list item 20.
My lord, within the time, my lord, within 15 days or something, my lord,
Yes.
because they are suffering, my lord.
You've said that. Yes.
Vehicle list item 20.
Obliged, my lord.
None appears dismissed.
Vehicle list item 21.
My lord, item number 21 may kindly be taken up 1 week after, my lord. We will file the recusite in the meantime, my lord. Inadvertently, we have not filed the recusite, my lord.
What's the matter about, sir?
Sir, it's my lord, it's a PIL matter, my lord.
What is
It
it
is a
about?
running shop.
My lord.
It is a running shop. Since long it is running. Now he is saying that it is objectionable. At the time of renewal, when objection will be invited, he will lodge
My lord,
objection.
without any objection, they have granted the license to the licensee for...
Again, at the time of renewal, another scope is there to object. So
My lord,
in
we have
April,
also
there will
given
be another renewal of the
consent
license.
authority. That is also not...
When is this operating? Since when?
It is operative since long.
My lord, we are challenging the order dated...
From August 2021.
2021, my lord.
August 2021. It will be again renewed in April after March. So at that time, he will raise objection.
Correct. The petitioner appears to be premature at this stage and is therefore not being entertained. Nevertheless, it will be open to the petitioner to seek appropriate remedies at the relevant time. Petition is disposed of.
Vehicle list item 22.
Wait, please, your lordship. There's a petition challenging the inaction of the opposite parties in not giving credit of the TDS amount in Form 3 issued under the Direct Tax with Vivad Se Vishwas Act.
Notice was already issued in this or not yet?
Identical matter for another financial year. Your lordship has passed order. I'm just passing on the order.
Yes.
Same order. There is another petition also, my lord, that is...
All right.
That petition I have already filed my counter
All right.
affidavit.
Notice, Mr. Satpathy accepts notice. Adequate numbers we serve the same thing. List on 7th
The
March.
other writ petition number I have mentioned at the top, my lord, that is 3762, same issue. Same issue.
Take
For a
note,
different financial
same
year.
order.
Grateful.
Vehicle list item 23.
My lord, this matter is a PIL and the petitioners are the Sarpanch, ward members and the villagers of the Madhupur village of the Dholimoa GP of the Khordha district. The petitioners have challenged the constant threat given by the state authorities, that is the railway department, for abolition of the level crossing, that is LC number 210 situated there. My lord, level crossings are provided on the railway lines to pass the road traffic across the track. As the road traffic passes at the same level on that of the railway track, the crossing is termed as level crossing. Other type of crossings are a road over bridge or road under bridge, where the road traffic passes over or under the railway track. In support of my case, my lord, at Annexure 2 series, page 26, I have annexed the data sheet of the traffic movement and a bare perusal of the data sheet would reflect that 108 trains each day passes over that railway crossing, and 5,000 villagers of
Any representations are there?
My representation is there, my lord, and also, my lord, in pursuance to my representation at Annexure 3 series, I have given they have given the representation to all the concerned authorities. The local MLA at page 39, Annexure 4, has also written to the DRM. And also, The Chief Minister's grievance cell receiving the representation has also communicated the same to the General Manager, East Coast Railway. But still then they are not taking any action and it is unnecessary. There is a...
Anyway, who's for the railways?
Millard, OP number 4. OP number
Who is appearing for them, sir?
Millard?
Who is appearing for the railways? Mr. Counsel, who is appearing for the railways?
Now ASG office is to take care of all the railway cases.
Millard, earlier there are so many panel advocates of the railways, and unless the notice goes,
No, you find out who's the standing counsel and let him take instructions. A copy of the petition be served on the standing counsel of the railways.
Millard, I have already served on ASG. Millard.
All right. You have to find out who's appearing for railways, you have to see. All right.
Millard, if your lordship directs, I will serve another.
We have just directed. List on. 20 March.
List for admission item 24.
May I please your lordship? Milord, it is that case.
Millard, lordship posted the case too. Is there any date?
28th March, sir.
Millard, I have filed a miss case.
24.
May I please your lordship?
Millard, in miss case also notice too.
Yes. Not notice, sir. You're not listening to the order carefully. We can't go on repeating for you. You apply, you make an inspection, you get a copy of the order. All right. Yes.
May I please your lordship? Milord, in this case has been argued repeatedly. Milord, your lordship may kindly see my writ petition, paragraph 2.
Yes.
This was notified and it was not acquired. I issued section 80 with a notified for acquisition up to section 6. Thereafter, they did not give me compensation, but the land were taken away because it is landlocked. If your lordship will kindly see my writ application, page 4, para 8. Para 8, because para 8, it was first acquired for SN Corporation. Para 8, as the SN Corporation have put up a boundary wall in their factory, it is not possible nor practicable on the part of the petitioner to possess the land described in the schedule below, as the same are surrounded by lands acquired by the EPICOL for SN Corporation. Then your lordship may kindly turn to their counter affidavit. I have placed repeatedly, but again I am pressing. They have said up to section 6.1, page 18 of the brief. Up to 6.1 process was undertaken. Thereafter, they did not acquire, according to them, they did not acquire the land. But the land is landlocked and it was within the possession of the other lands. And in the counter affidavit, if your lordship will kindly see, page 18, para 15. Para 15, in reply to the amendments made incorporated in para 5 of the writ, it is humbly submitted that they are not correct and hereby denied. It is further stated that the land in Sabik, these two plots, 1434 by 150 had not been acquired and possession of which was never taken by the land acquisition. Again, Milord's para 18, that in reply to the statement made in para 8 of the writ, it is humbly submitted that the deponent has nothing to state. In para 18, I have stated it is within the lands of the SN Corporation. Then your lordship may kindly see the first reply given by the state at page 34 of the brief. Second reply, 34 of the brief.
Yes.
That is the letter of the Tahsildar. If I am permitted to place which reference to the letter of the subject cited above, I am to intimate you that Honorable High Court in its order dated 14/10/15 had directed to the collector to give the present status of Sabik plot number 1434/15303 and 1437 under Khata number under village Gundijapada. It is ascertained from the office of the ROR that the mutation case was instituted by case number suit land has been transferred in favor of EP Tata. Without EP Tata, possession was taken over in EP Tata.
Now, my lords, your lordship on that day asked, they have given a affidavit. Counter letter, my lords. That letter they have said that counter them. Then your lordship last time asked me to verify the counter dated 17/12/21. Your lordship, I kindly see the counter dated 17/12/21. Paragraph 4, they have said, it is respectfully submitted that during pendence of the writ petition, pursuant to order of this honorable court, the predecessor of the deponent has also filed affidavit stating the true state of affairs in as much as though the notification of the plots for which petition urging compensation were not included to be acquired, yet the said lands were recorded in the name of the company, the fact which has been vividly incorporated in para 5 of the affidavit. Then the next parameter say, submitted though initially steps were being taken to acquire the said 2 plots by way of notification under section 6(1) of the LA Act, yet subsequently, for some reason, the 2 plots were not acquired, hence the question of calculation of compensation doesn't arise. And they also say the register doesn't.
Mr. Das, let us ask the other side.
My lord, what has happened? Actually, he is the owner of these 2 plots and it is inside the company boundary. And my affidavit is that it is in the possession of the company. But what has happened, earlier notification was withdrawn so far as the acquisition is concerned. This is the, and there is no acquisition so far as.
To deprive him of possession, deprive him of compensation, nothing. He gets nothing for what? This is like taking over land without anything.
Because my affidavit is that company is also not depositing the compensation amount for this plan. Your lordship may ask the company lawyer, because my affidavit I have stated company is in possession. The company lawyer is also appearing before your lordship.
Who's for the company?
Yes, my lords. My lords, on 20th January 79, I have deposited the entire amount for 33.15 acre of land. Thereafter, my lords, only out of that 32.80 land was allotted to me, my lords. So my counter annexure 1, I have also annexed that, my lords, that receipt. The entire amount, the lordship got it.
No, do you need this land or you don't need this land?
I need, because my lord, this land is inside my factory, my lord. So supposing also your lordship directed to provide them, that is inside, that is the middle of the company, my lords.
This is landlocked. It's a landlocked.
What are you doing with the money, sir? Mr. Monty.
No, my lord, so far as this land is concerned, my instruction is that money has not been. May I suggest one thing to your lordship? Your lordship may direct the collector to hear both the parties, the company representative and the petitioner. And if at all their land is under possession and company is liable to pay the compensation.
No, the company is already deposited compensation
that
for this land.
that is also a disputed question of fact. Company is saying that he deposited for 33 acres, 15 decimal of land property in Gundichapada. But my affidavit is that for this land, there is no deposit for these 2 plots. That is a disputed question of fact.
What does that mean? The same extent of land we are talking about.
But now
how can you say separate it out?
Payment register I have also annexed that it shows that no payment has been made to the petitioner. So that is what my
no payment has been made to the petitioner is one part of the story. What have you done with the payment made to you by the company? What have you done with the money deposited with you by the company?
No, company has not deposited the money for this particular.
No, who will tell us the truth, sir? There are 2 opposing narratives here.
Yes, that is a paucity of fund. The fund which he had deposited, there was a paucity of fund. That is a specific affidavit. Your lordship may kindly see the affidavit of the Tahsildar, first affidavit which I have filed, para 5. So for an amicable solution, your lordship can directly collector to hear both the parties and
amicable means you are not going to agree that you have received the money.
That is the counter. That is the counter.
In mediation or before the collector, will you agree or will you take the same stand?
No. Collector.
You will take the same stand. You're taking before us.
Tahsildar will appear and submit the records, and the company people will come.
No. Tahsildar, is he going to take a different view from what you are saying now on affidavit before us?
Not Tahsildar. The collector will examine. That
Sir,
whether
let
any,
me be very clear. If this is to buy time at the end of 6 months.
No, by time. Only 1 month time your lordship may direct. Otherwise, the collector will submit the report to the
End of the whole of it, if the collector is going to be in the same denial that you are, you say, I have not received any money for this. Where does it leave the petitioner?
That has to be verified from the records, because company has to prove it that for this, because we have received for this particular piece of land, which is not inclusive of the suit land.
How do we know that, sir? That you have received only for certain land and not the particular suit land? How do we know that?
Because may I pray intervene 1 minute? The land was first acquired for SN Corporation. Then SN Corporation went away. They did not continue with the factory. It was again given to Ipitata. Then now third party has come. Since 79, I have been deprived of the land for the action of the state, not for anybody's action.
Sir, do you have the covering letter that you sent them when we made payment?
Yes, madam.
No, sir.
Company.
I can't be asking you the question. I'm asking the company.
Yes, my lord.
Where is that letter?
That letter, my lord, I have to collect, my lord, only that.
Do that. We don't want to know whether
Yes,
in fact you paid for this particular land or not.
That document, my lord, I'll submit along with the affidavit, my lord.
The company's lawyer says
Yes,
that
ma'am.
he will within a week, within 2 weeks, file an affidavit enclosing the relevant documents which would show that the company has in fact made payment to the government for the land
My lord may say that
stated to be belonging to the
deposited
petitioner, which is
compensation amount in respect of the
within
land
the company's factory. This has become necessary because Mr. D.K. Mohanty, learned AGA, maintains that they have not received money for this said parcel of land. The affidavit be filed within 2 weeks with an advance copy to constitute the other parties who are permitted to respond to it before the next day.
My lords, 1 second, my lords. I have deposited the entire amount for a patch of land, my lords. So possible I cannot segregate this much amount I've deposited.
No.
So now you're singing a different tune. You better file an affidavit now.
That 33.15 acre for
No. You file an affidavit, sir. You file an affidavit. You have recorded your statement that you've already made payment for this land.
Yes, ma'am.
13th April.
Public.
13th April.
Weekly list item 25.
May I please, Your Lordship? Here, my lord, this is the third round of litigation before this honorable court. For that, I filed a date chart before this honorable court on 22/8/2016. Some facts are necessary for this adjudication of the case. Lordship, may kindly have a glance at.
Say it, sir. No
Yes, Your Lordship. Yes, Your Lordship. That the petitioner in the present writ application have challenged the order of the member board of Orissa Cuttack dated 27/2001 OEAK revision number 53 so and so under section 38 of the OEA Act, insert the and up for quashing of the said as illegal, arbitrary, and the subject matter of dispute was recorded as Anabadikata of the ex-Jamindar. And on 5/7/48, the landlord registered permanent lease number so and so leased out the area measuring so and so land in the Mauja Boydepur Baleswar Hal district Bhadrak in favor of Vishwanath Maiti. And on the same date, the landlord another registered sale deed number leased out the 10 acre in same Mauja in favor of one Kushna Chandra Samant, and the land was vested to the state government on March 1952. Thereafter, the ex-intermediary submitted the Ekpadiya and the lease on respective leases basing on the tenant's ledger, and open and rent was collected by the state functionaries till 1955 and 56. Thereafter, one miscase number 143 of 1971 was under section 5I of the was initiated by OEA collector against the Vishwanath Maiti and his bandits. Thereafter, the collector did not initiate proceeding under section 5I of the Act in respect of the property of plot number 2. That on 71, the OEA collector set aside the lease dated 5/7/1948 in favor of Vishwanath Maiti in lot number 1, and against that order, the present
petitioners have filed the original suit number 2 of 1974 challenging the proceeding under section 5II of the Act, and the learned civil judge, subordinate judge Bhadrak, has allowed decreed the suit, and thereafter the opposite party number 153 had preferred the appeal before this honorable court. It by first appeal number 154 1976, where this honorable court directed to consider the lease, and again they have on the basis of the order of this honorable court, they have initiated the proceeding, and they have found that the lease, permanent lease deed is valid, genuine, and thereafter on some days, 1 month thereafter, they initiated another miss case for recall that order and reviewed that order. Thereafter, I'm challenging that said order. I filed another writ application before this honorable court, and this honorable court particularly directed, but order dated 5/9/95, directed to miscase not dealt with by the member under section 5 first provision from the confirmation of the rest property on lot number 1. And admittedly, the said registered deed as valid, genuine, and then they confer, and thereafter, instead of, in view of this honorable court's order, they have to refer the matter under section 5I of the Act. Instead of doing that, they have referred the matter, they have state through collector has referred the matter under section 38 of the Act. And the Lordship may kindly have a glance 5I proviso, what proviso says. First proviso.
My Lord, exhaustive order has been passed by the Learned Board of Revenue, and the lease is found to be fraudulent, and the same type of.
It's not a Sukhinda matter.
Same type of litigations. But there is no limitation, at least in this case, I think.
Now, where is the land? Sukhinda?
No, Bhadrak.
Bhadrak. Another district.
Bhadrak district.
These are all motions under section 38B. The collectors, all the previous leases granted, allegedly granted by the ex-jamidars.
Yeah, and no jagirs. They are not showing any hold.
Found to be all fraudulent and rampant cancellations.
That is the all registered document I have placed.
No, you have not registered.
The registered document I have registered under the 1948 is a registered document. It's not a pathpata or something like that. The fraudulent can.
There was a civil suit here.
This honorable court specifically directed to refer the matter under the first proviso of the 5I. Can it be equated with the same as the 38B? The OEA collector is as permitted to place 5I, the provide.
Yes.
The provided that in case where the collector decide not to set aside any such settlement, lease or transfer, he shall refer the case to the Board of Revenue for confirmation of the settlement, lease or transfer, and the order passed by Board of Revenue shall, in this behalf, shall be final. Under this act, who is the collector? Lordship may kindly have a glance. 2D. 2D says, collector includes the officer appointed by the state government to discharge all or any other functions of the collector under this act. Thereafter, Lordship may see by notification dated 9 February 1963, they have constituted some collectors. Lordship, finally permit me, in pursuance to clause D of section 2 of the Orissa State Abolition Act, the state government do hereby appoint following officers to discharge the functions of the collector under clause I of section 5 of the said act in respect of the areas specified against each without prejudice to any power of the collectors in respect of dispute any other offended on the collector under the said act to discharge the said function in respect of the district. And here my serial number 56 the subdivisional officer Bhadrak, Balasore district, and Bhadrak division under the Balasore district. And here the reference, you'll also kindly say annexure 1. I have annexed that document. Who has referred the matter? Here the collector means the collector of the district has referred the matter. Under annexure 1, I have filed that document, the reference made by the state government at page 11.
Yes.
State of Odisha through collector Bhadrak. Under this act, under section 5 says the collector means the subdivisional officer of the Bhadrak. He has to file an application, not under 38B. And this honorable court specifically directed to send the record or refer the matter under section 5I of the act, not under the 38B of the act.
Will reserve orders. Orders reserved.
List item 26.
May I please, Your Lordship, my lord, I am permitted to address Your Lordship from VC, my lord.
Yes.
My lord, in this case, Your Lordship may kindly see the last order dated 7/12/2021, whereby Your Lordship had directed NALCO, basing on their statement made in the counter affidavit, to file an affidavit whether they have received the refund of the amount or not.
Yes.
They have filed an affidavit simply stating that they have not received any refund. Mr. Mishra, just a second. And in this case, my lord, Your Lordship may kindly note the state government has not filed any counter as yet. They have simply filed an affidavit.
Your Lordship, in identical matter, Your Lordship has already decided in the identical issue, Your Lordship. Your Lordship, that order I am submitting. Your Lordship, annexure 7.
My lord, I am sorry, my lord.
Let me complete. At
I'm
annexure
sorry,
7, Your
the
Lordship.
state government has not filed its counter
At
as
annexure
yet, my
7,
lord.
page 27.
And Your Lordship has
NALCO.
Sir, don't
order
interrupt.
dated-
Either you argue or let him argue. Don't interrupt, please.
My lord.
We're not able to hear you simultaneously.
My lord, sorry, my lord.
At page 27, annexure 7, NALCO has admitted that NALCO has disclosed the enter receipt in its return, Your Lordship. That return has been adjudicated by the sales tax department of NALCO. And one assessment order has been passed. In the assessment order, there was refund of 29 lakhs. And what I think, Your Lordship, that refund might have been adjusted with the subsequent year demand.
This might have been is the problem, sir.
Your Lordship, that is a separate cause of action. My respectful.
Why don't you file an affidavit? Tell us what has happened to this 29 lakhs.
Your Lordship, I'll file. Some time may be granted, Your Lordship. Also, the affidavit filed by NALCO has not been served to me, where he has denied that refund has not been issued.
Mr. Mishra, learned counsel.
May I submit one thing, my lord, with Your Lordship permission?
Seeks some more time, seeks and is granted 2 weeks time to file an affidavit explaining what has happened to the refund of rupees 2957,180, which NALCO was supposed to receive. List on 18th April.
Grateful, Lord.
Weekly list item 27.
May it please, Lordship. It is relating to the implementation of Justice City Commission of Judicial Lower Judicial Employees, my lord. Your Lordship, Your Lordship kindly see order dated 16/12/2021. 16/12/2021, Lordship had directed us to ascertain the information regarding the subsequent commission. Your Lordship kindly see order dated 16/12/2021.
So what's the position, sir?
I have filed the affidavit that commission is not related to judicial employees, only to judicial officers. For that reason, my lord, I have also filed affidavit. Kindly see the affidavit at flag M. Flag M, my lord. M for madras.
So it's not about judicial employees, is it?
No, only not about judicial employees. It is about only judicial officers. That they have their lordship, the Supreme Court has also. I have also given the Supreme Court orders, my lord. Orders of the Honorable Supreme Court. They have also their lordship also made it clear. I have filed in that affidavit. I have filed along with that.
Where is that, sir? Where is your affidavit?
Flag M, my lord. AM for Madras. Lord, you kindly see.
Yes, you got it, sir. All right. An affidavit has been filed with the petitioner clarifying that the Justice P.V. Reddy Commission is dealing only with the pay scales of judicial officers and not judicial employees. So now what happens, sir?
My lord, out of all these accounts, only 4 recommendations left to be implemented. I am because at the time of filing it applications, many recommendations are not implemented. But in the course of time, they implemented.
It further adds that as of date, only 4 of the recommendations of the state of Orissa remain to be implemented. Mr. Mudli, what do you plan to do?
Yes, because annexure A, that is annexed to the recent affidavit, well, I will obtain instruction on this annexure A, whether these
All right.
4 have been
Mr. P.K.
complied with.
Mudali, AGA states that he will seek instructions.
They have already also filed affidavit. Earlier, they have also filed affidavit. Let them obtain it.
27th April.
Obligement.
Quick list item 28.
My lord, the petitioner is a retired district judge. The petitioner is a retired district judge.
Yes.
And in this writ petition, he is claiming, my lord, super time scale from the date his juniors got that scale.
All right.
My lord, all his junior 3 to 24 have already retired. In the event of success, my lord, I won't claim any area. My lord, I have filed the civil list that opposite parties 3 to 24 were junior to me. In para 7 of the counter, 8 of the counter, the authorities have also admitted, my lord. They have said the opposite parties number 3, para 8, my lords of the counter, 3 to 24 were junior to the petitioner as per the civil list. Then, my lord, in 2001, my lord, opposite parties 3 to 11 were considered for promotion to Orissa Superior Judicial Service Junior Bench, my lord, in 2001. My case was not considered, and that is also admitted. My case was not considered, though they were junior to me. They have given in para 9, my lord. They have said, my lord, they have said that it is humbly submitted that case of the petitioner for promotion from OJS class 1 to the cadre of OSJS junior branch was taken up along with OP number 3 to 6 and others. Here, my lord, but his case was not considered. They have admitted in view of the allegation pending against him. They have admitted not considered. So far as allegations are concerned, my lord, in 2001, the promotion, they were promoted. There was no allegation in 2001. My lord, the 2 allegations only. The 2 allegations came in 2002. I have admitted, my lord, in para 14, the authorities of the counter, my lord, at page 50, the authorities have, this is only that there was no allegation in 2001, only 2 allegations, they came in 2002. I will explain how these allegations were, without substance later on. So in para 14, they have admitted, page 50, my lord, it is humbly submitted that the averment regarding initiation of disciplinary proceeding number such and such against the petitioner under 3 heads, alleged in the court 50 months later. This is 2002. This is one allegation, my lord. When you was civil judge in senior division of Sambalpur, this departmental proceeding, I will explain that. And the second one, my lord, second also, they have admitted 2002, my lord, this is at page 65. It is respectfully submitted that superseding the petitioner by here, that in reply to averments in para 7, 18 of the counter, it submitted that while the petitioner was functioning as DJM, Uddala, on the basis of a report of the then district judge Moribund Honorable Court, initiated an administrative inquiry in 2002. So, my lord, these allegations came in 2002. In 2001, there was no allegation. My lord, in my humble submission, promotion is given, is made on the basis of performance as reflected in the CCRs, my lord. My lord, then in 2001, opposite parties 3 to 6 were considered for promotion, my lord. It is not known whether 3 years or 5 years CCRs were taken into consideration. My lord, if 5 years CCRs were taken into consideration, petitioners 4 years CCRs were good and another year very good. My lord, the CCRs from 84 to 2009 have quoted in that compulsory judgment. So 4 years good, my lord. Now all the opposite parties have retired 3 to 24 and getting the super time scale, my lord. So they have admitted, my lord. Therefore, my lord, 4 years good and 1 year 97 are very good. These were all prior to 2001, my lord. So in my respectful submission, in view of the good CCRs and very good CCRs, no allegation 2001, non-consideration. Of course, the consideration is not mere consideration. The consideration should be in essence, my lord. So not considering my case as admitted, my lord, there was no allegation in 2001 is violative of the of my fundamental right under Article 16(1) of the Constitution of India. Therefore, my lord, I humbly submit that I shall be treated as OSJS Junior Branch Officer of 2001.
All right. Mr. Mudali.
Your Lordship,
My lord.
the promotion
My
is
lord.
not based on seniority only. It is based upon merit comes seniority. Your Lordship, paragraph 9. And
Yes.
in the year 2001, his case was considered along with others, but he was not found suitable. And why he was not found suitable, that we have stated, because of allegations pending against him. Then
No,
in
let me explain.
Mr. Dora, kindly do not interrupt. We listen to you very patiently. You'll have to
No,
listen
I
to
will
the other
listen,
side, sir.
but in the middle, I can't be stopped, my lord. I am continuing. I have not finished, my lord. 2001. Then comes 2006 promotion, my lord, to the senior scale. There also I was not considered. I was considered subsequently. Let me finish, my lord. Or if your lordships want, let the other side argue. As your lordship wish, my lord.
All right, you finish.
Yes, my lord. So this is so far as 2001 is concerned, my lord. Then, my lord, about these, about these, my lord, 2001 promotion, my lord, I made a representation, my lord, in 2001, that is at page 65, my lord. I'm just placing, my lord. My lord, when he was SDJM, Uddola, my lord, a theft occurred in the Malkhana, my lord. That was a Sunday, and the petitioner was holding Lok Adalat at a different place. My lord, his explanation was that 65 that, my lord, only one watchman was sanctioned, and he was not on leave, my lord, he was on duty. Therefore, the allegation that I did not make alternative arrangement is without any basis, my lord. This is admitted, they have not denied, and my lord, it is to no purpose, my lord. So this is completely misconceived and without any substance, my lord. Only one watchman was sanctioned, he was not on leave, he was on duty. So where was the scope and need, my lord, to make alternative arrangement? Therefore, my lord, this allegation is to no purpose and, my lord, without any substance. My lord, about the second allegation, my lord, that I was slow and careless and came to the court 15 minutes late, my lord. My lord, I have explained that one. I can read out or I can also explain, my lord, that one pool car was picking up all the officers, my lord. One or two other officers, not myself, petitioner, my lord, might have been not ready on time. Therefore, there was a delay of 15 minutes and every officer came 15 minutes late to the office. The second, my lord, the petitioner was slow and careless in disposing of civil matters, my lord. For that, my lord, a senior officer was appointed as inquiry officer. I am reading out, my lord. It is further averred by the petitioner that during his incumbency as a civil judge, protocol judge made a surprise visit of the station, and on the basis of the inspection report, a departmental proceeding was initiated against him. The charges of the proceeding that the petitioner came to court 15 minutes late, the petitioner was careless in disposing of civil cases in the month of June 2002, and the petitioner took 1 month time to pass the degree, though the petitioner, plaintiff bank accepted one-time retirement, and the petitioner passed an interim order of injunction is arbitrary, which was set aside by the district judge. Only 2 remain. My lords, in his show card to the first charge, the petitioner explained that the pool car, while picking up different judicial officers from the residences, 1 or 2 officers were not ready in time, and therefore all the officers who came by the pool car reached office 15 minutes late. As regards the second charge, my lord, the petitioner explained that as per the prescribed yardstick, only 2 title suits were disposed of in a month, and one of the 2 suits relating to the bank arguments could not be completed before the summer vacation, and that the same was completed only on the reopening of the day, and the judgment was pronounced on the very next day. The third charge was, however, dropped. A senior judicial officer was appointed as inquiring officer, who, on completion of inquiry, gave the finding that the petitioner rendered adequate outturn in the month of June 2002. Therefore, he cannot be said to be slow. My lord, in spite of that, in the punishment of censure was awarded. And in that theft case, my lord, I was cautioned. My lord, both these allegations, as I have explained, without any substance, my lord, and to no purpose. Yet, my lord, I did not challenge before this honorable court, fearing that, caution and censure, my lord, fearing that this honorable court would be displeased, my lord. But they are to no purpose, and they cannot be utilized or used, my lord. My lord, next comes, so I have explained that no allegation in 2001, they came in 2002, and allegations I have explained, they are without substance. Next, my lord, in 2005 and September 2006, my lord, some of the opposite parties were promoted, my lord, to OSJS senior bench, my lord, in September 2006. My lord, after a gap of 3 months, I've stated that, after a gap of 3 months, that is Annexure 8, my lord. After a gap of 3 months, no, I would say that. My lord, after a gap of 3 months, I was promoted, my lord, to the senior bench, OSJS. My lord, September 2006 and December 2006, 3 months gap, my lord. I was promoted to senior bench after 3 months, but when my junior was considered in September 2006, my case was not considered. When after 3 months, I became fit, my lord, and suitable, had they considered in September 2006, I would have got that, my lord. My lord, against this, I made a representation, my lord, in 2006. First representation I have already explained. They have said, my lord, that 165. My lord, so far as the first representation in 2001 itself, I made a representation. They have replied by saying that my representation became infructuous because I was promoted as a CGM in 2005. My lord, my representation was against 2001 non-consideration. They say I was promoted after 5 years, so it became infructuous. This is unheard of, my lord. And secondly, for late promotion to senior scale, I made a representation. They kept quiet in 2006. Then, my lords, I made another representation in 2009, my lord. So both 2006 and 2009 representations were disposed of as per Annexure 11, my lord, page 44, without giving any reason, my lord. They have just, my lord, 1 second, my lord. They said, Page 44, my lords, Annexure 11, representation of so and so. Sir, with reference to letter number such and such on the above subject, I am directed to say that on careful consideration of the matter, the court are pleased to reject the representation dated 7109 and month, etc. They have not given any reason, my lord. No barred order, my lord. They have rejected. Both 2006 kept pending for 3 years, 2006 and 2009. Both they have represented at a time as per Annexure 11, my lord, in 2011. And I filed this writ petition in 2011. My lord, September, I'm sorry to repeat, my lord. In September 2006 and December 2006, in December 2006, I was promoted to senior branch OSJS, my lord. And in September 2006, my junior was promoted. My lord, 3 months gap, my lord. They should have considered. And secondly, my lord, lastly, I am submitting, my lord. My lord, 744, my lord. These, I have already explained how the allegations were without any substance, my lord. Therefore, my lord, had they been considered as adverse, my lord, they would have reflected in the CCRs, my lord, ACRs. So far as those 5 years, 2001 promotion was considered, non-consideration, did not reflect at that time, they were not there. So for senior scale promotion, though I was promoted after 3 months, my lord, 4 years CCRs were considered. 4 years, my lord. And all the 4 years, my lord, my performance was found good, my lord. My performance was found good. And these two punishment, minor punishment, my lord, caution and censure. If they were with substance, they would have been reflected in the CCR, not reflected. Even had they been reflected, I mean, without any substance, there is no purpose, my lord. So that one. Therefore, my lord, they have rejected this one. Therefore, my lord, as I have stated my quarrel of judgment. My lord, my lord, in the compulsory retirement judgment, my lord, your lordships are aware, compulsory retirement is made to weed out deadwood, my lord. And the performance is reviewed, my lord, at 3 stages, my lord, on completion of 50 years, 55 years, and 58 years, my lord. On review of my performance on completion of 50 years, I was compulsorily retired, my lord. My lords, I challenged that compulsory retirement. Of course, the division went quashed and treated me as continuing service. So there in that judgment, my lord, that has been annexed to my rejoinder, my lord. This judgment has been annexed to the additional affidavit, my lord, judgment. Only one para I will place, my lord. My lords, in para 21, my CCRs from 84 to 2009 have been quoted, my lord. And those 5-year CCRs, 4 good and 1 very good, all prior to this, my lord. And the second one, 4, my lord. Your lords will find when the consideration was made in 2005 and September 2006, my lord, from this 84 to 90, my CCRs were very good, my lord. First one, very good, 1, my lord. My lord, only one para I will read out to your lordship from the judgment, my lord, about those allegations, I mean those minor punishments, my lord, caution and censure. As I have explained, they were all misconsidered and without substance. My lord, just one para I am reading out to your lordship, my lord. In the instant case, the 3 instances of remote past for which the petitioner was cautioned and censured were of very minor nature, and the same were considered while reviewing the service of the petitioner at the age of 50 years. And the review committee, as well as the full court, did not give him compulsory retirement at that stage and allowed him to continue in service, evidently considering the said incidents are not justifying giving a compulsory retirement. Thereafter, the petitioner was promoted to the cadre of discharge, even those incidents did not furnish ground for withholding promotion. As to conduct and performance, except for the year 2008, there was no allegation about his integrity. On the other hand, the rating of the petitioner was average only for 2 years, 2001-2006, was also available to the review committee, as well as the full court of the High Court during the review of the service at the age of 50 years in November 2008. These ratings and 3 adverse remarks described earlier would not persuade the High Court to give compulsory retirement to the petitioner then. His ACR for the other years was good and very good. Therefore, without there being an additional or further adverse remark, service record and having regard to the decision of the court in the case of, my lord, the lordships are referred to about 10 or 12 decisions, my lord. Vasudev Rai, you are of the opinion that the court's decision to retire the petitioner compulsorily is arbitrary and unreasonable, and therefore the impugned order of compulsory retirement under Annexure 9 cannot be sustained, and accordingly quash the said order. The petitioner has crossed the age of superannuation, 60 years, and therefore there is no scope to direct his reinstatement in service. However, we direct that he must be deemed to have continued in service from the date of his compulsory retirement till the date of his superannuation, age of 60 years, and shall be given his salary at the time scale of pay for the post he was holding from the time of compulsory retirement for the said period, and also retirement benefit. My lords, all the opposite parties who were junior to me, 3 to 24 have retired, my lords. I am not seeking any relief against them, my lord. And here your lordships have seen non-considered 2001, illegal, unconstitutional, my lord. So also, my lord, in 2006, my lord. They promoted me in December 2006 and juniors in September 2006, 3 months earlier. My lord, had they considered in September 2006, I would have got it. And these, both the allegations, my lords, are without substance. As I said, to repeat, I did not challenge, fearing that this honorable court would be displeased, my lord. They are to no purpose, cannot be utilized, and have not been utilized also. Minor punishment. That's all, my lord. My lord, I prepared the written argument, my lord. I prepared the written argument, my lord. We are just my lord,
three prayers have been made. First prayer is for quashing of Annexure 11. Second prayer is for quashing of Annexure 9. And the third prayer is for grant of consequential service benefits by granting promotion with retrospective from 25/8/2001. Here in the instant case, the rule governs that the promotion has to be given on the basis of merit cum seniority. Now, let's kindly turn to paragraph 9 of our counter affidavit.
Yes.
Paragraph 9, 10, 12, 15, and 16. And there we have stated that from August 2001 to March to May 2003, the case of the petitioner was taken up 8 times for promotion along with all other junior officers. And all those times, his case was not considered in view of either allegation or disciplinary proceedings pending. And finally, your lordship may place all the relevant dates, your lordship, in the paragraph 9. And his case was considered on 25/8/2001. Subparagraph, it is humbly submitted that the case of the petition for promotion from the cadre of OJS Class 1 to the cadre of Orissa Superior Judicial Service Junior Branch was taken up along with the OP number 3 to 6, and but his case was not considered in view of allegation pending against him. Now you look at the paragraph 10. Towards bottom, you look on 6/3/2002, his case was considered along with the opposite party number 8 to 11, but his case was deferred in view of the allegation pending against him before the Vigilance Committee. Now let's see paragraph 12. On 1/8/2002, the opposite party, the case of the petitioner was considered along with opposite party 12 to 13, but his case was deferred in view of the allegations pending against him before the Vigilance Committee and the full court. The next subpara, 22/8/2002, the case of the petitioner was considered along with opposite party number 14. But his case was deferred in view of allegations pending against him before the Vigilance Committee. Then again on 10/10/2002, the case of the petitioner was taken up along with opposite party numbers 15 to 19, but his case was deferred in view of allegations pending against him. Then again on 31/10/2002, the case of the petitioner was taken up along with opposite party number 2, but the case of the petitioner was deferred in view of the allegations pending against him. Now we will page paragraph 14. In the year 2002, disciplinary proceeding was initiated under 3 heads, and after completion of the disciplinary proceeding, minor punishment was imposed. Then in paragraph 16, we have stated on 29/11/2002, the case of the petitioner was considered along with the opposite party number 21, but his case was deferred in view of the allegations pending against him. Then again on 7/5/2003, the case of the petitioner was taken up along with the opposite party number 22, but he was not found suitable for promotion. Well, all these times his case was considered for promotion, but since he was not found suitable, his case was not. So in my submission, since the petitioner was not found suitable for promotion, and the rule provides for promotion on the basis of merit cum seniority, so he is not entitled for promotion with retrospectivity, that is 25/8/2001, and consequential benefit, financial benefits.
What is the result? My lord, to reply only 1 minute, my lord. So my learned friend's entire argument is based on those allegations, not considered, deferred, all that. I have already explained, my lord. Both the allegations are without any substance, my lord. I have already explained. My lord, another thing I would like to submit, my lord. If my promotion was deferred or not considered because of these 2 allegations, caution and censure, my lord, then it would amount to major punishment, my lord. And the same 2 minor allegations, my lord, those allegations, if on that basis, if they say that my case was not considered, then it would amount to major punishment, my lord, violating Article 311(1), my lord, for not giving opportunity and all that, my lord. And thirdly, my lord, he says it was on merit cum seniority. Yes, on merit cum seniority only, CCRs were prepared, merit cum seniority. So 4 years good, another year very good. And for a junior bench, for senior bench, 4 years good. So, my lords, in humble submission, there is nothing in the counter, my lord. Simply they rely on those 2 allegations, entire case. That's all, my lord. Written note, my lord. May I place my lord, written note?
Quickly list item 29.
My lord, about this written note, my lord.
Yes, we have it.
My lord.
We already have a written note from you, sir.
My lord.
We already have a written note from you, sir.
Yes, my lord. I am grateful, my lord.
Item 29, my lordship. In terms of the NCLT proceeding, my lordship, there has been a change in management, my lordship. And I have filed an affidavit to that extent, my lordship. My lordship, similar matters of the self-same petition has already been disclosed.
That copy didn't not to us, so no. Motion still, yes, that's. I think a general is taken up.
Same order.
Quickly list item 30. Quickly list item 30.
30 question is framed page 9, whether in the fact and circumstance of the case, the learned IT8 is correct in deleting the addition of rupees so made by the EO on account of closing stock valuation, and the assessor failed to complete the accounting standard which is mandatory for it. The para 6, paragraph 5, the revenue was explained. If I'm permitting to place I have placed the detailed fact arising out of the order of the IT18. I'm placing the 6th line of paragraph 5 of my appeal memo.
Appeal memo?
Yes.
Why don't you read out from the input order and tell us?
The tribunal relying on the previous order has accepted the view.
They're not challenged matters.
Ah,
It was never challenged.
Let me complete.
Yes.
Let me
That
complete.
was
You have
never
enough.
challenged.
Let me complete 2 minutes.
Starts from 102, the
So-
order of the tribunal.
So my submission is, if I'm please, the Lord and ITS error in upholding the decision of the Lord and CIQ appeal on this issue without appreciating the fact that accounting standard of AS9 was mandatory for the assessee as per classification issued by CISA in January 1994, and by not following it, the income was underreported to the extent of income amount to be sourced by its father. The Lord and ITS not consider the fact that cost of formula
So
valuation
just come to para 3 of the impugned order.
of tribunal. Yes.
Depend one.
Revenue appeal relates to the commission.
Para 3, sir.
The learned DR.
Internal page 3, para 3. Was it 2.1? Whatever. That stamp is on it. So
Yes, yes.
round numbers 1 to 7 in the revenues appeal.
Yes.
Appeal relate to. And last line reads, the learned DR
1
was
minute, sir. Let him read. Let him read, sir.
Submission of the learned dear. Next is grounds number 1 to 7.
Yes.
That in revenue appeal relates to common issue relating to the valuation closing stock. The assessor submitted in its written submission, and the written submission state that AO made valuation of rupees so and so in the value of closing stock by valuing the closing stock at the net realized value, while the assessee was valuing the closing stock constantly on the cost of market value, whichever is less. As stated, the issue was duly covered. This
Fair enough to concede. That's the end of the matter, sir.
He is not reading it.
All right.
Learned DR was
The
fair enough to
department is an appeal against an order dated 8 November 2013 passed by the ITA in ITA number 163 /CTK 2013 for the assessment year 2009-10. The issue rejected by the department concerns the deletion by the ITAT of an addition of the addition made by the AO on account of closing stock valuation on the ground that the assessee had failed to comply with the accounting standards, which was mandatory for it to follow.
141, 45A.
In the impugned order of the ITAT, in para 2.1, it has been specifically noted that the assessee had pointed out that it was valuing closing stock on cost or market value, whichever is less, whereas the AO is seeking to value it at net realizable value. So the issue was covered by the decision of the ITAT for the preceding years, that is 2006-07 and 8-09 in favor of the SSC. The ITAT then noted, open quotation, the learned DR was fair enough to concede the position, full stop, unquote. It is not sought to be urged before us that the above concession was erroneously made, full stop. Also, following the rule of consistency, the court finds no reason to interfere. No substantial question of law arises. The appeal is dismissed.
Weekly list item 31.
Item 31, I am for the opposite party, my lord. I am from the BC, my lord. I am for the private opposite party.
None appears dismissal number.
Weekly list item 32.
At weekly list item 32, I am appearing on behalf of the petitioner on instruction of BC, my lord.
Yes.
My lord, I had sought for instruction to file rejoinder, but it seems that the petitioner are not willing to pursue the matter anymore.
Counsel, the petitioner states the petitioners are not interested in pursuing the matter anymore. The petition is disposed of.
Weekly list item 33.
But in this matter, I have no instruction. If any cause of action survives.
No, not necessary. No instructions disposed of.
Weekly list item 34.
Yes, ma'am. May it please, ma'am.
Yes.
Let's pursuant to your lordship's last order. Your lordship just sees the paragraph 3.
Yes.
In the present case, the Settlement Commission has already disposed of the petitioner's application for 31st July 2018, and therefore it cannot be considered a pending application. The question then arises if the court were to agree with the petitioner that the Settlement Commission ought to have considered the effect of the payments made pursuant to common cause in the light of stand taken by the revenue in the additional note of submissions handed over today, that such payment is not an allowable expense in the hands of the assessee, can the matter be remanded to the aforementioned interim board of settlement? And if not, what are the remedies to the petitioner? So no remedies suggested. An answer given that since the matter has already been decided by under 245D4 before 31st January 2021, so therefore we can't do anything. And the answer to your lordship's pertinent question, which is in two parts, has been answered like this. A, on remedies, none. On two, because it's been prior to 31st January 2021 and 2017, so therefore not. Now, this is evident by page 7 of the additional written submissions by the respondent. The Settled Commission stands abolished. This is the reason given. But that is what your lordships already note in the order. Now, the second, the settlement application was disposed of in July 27, which is also a matter of record. So basically, at page 7, as regards sending the matter to Settled Commission and your lordship's order, the submissions really don't answer the question. But be that as it may, yes, I have also filed a reply to them, including the basic factum that now the respondents say that the payments made pursuant to common cause, and which are in quite a substantial hundreds of crores, yes, they are penalty. Now, this is the assumption of the revenue. They are penalty. A common cause itself says it is not. It is compensatory. Karnataka Rare Earth Malad says it is compensatory, not to be treated as penalty. The demand notices that were issued to me were for the relevant assessment years 2009, 2011, 12, 13. Now, the revenue takes a stand because it has been submitted in 2017. Therefore, it cannot be allowed as expense because it is penalty. No, but this is a position, as I see it, Murad, further from the position of law. But I have, Murad, also filed my written submissions on Friday because I received this reply quite late. They may not have come on your lordship's record. All that I wish to say today is, Murad, your lordships can have the matter now for a final disposal on physical mode anytime as convenient to the honorable court.
All right. You say an additional written submission has been presented to the court on behalf of the department, stating that since the Settlement Commission stands abolished, there is no remedy available before it for the petitioner. And that in any event, since the orders in case of the petitioner were passed prior to (2021), there cannot be any revisiting of the said orders by the Commission. Paragraph, a reply has been filed to the said written submissions by the petitioner on 18th February 2022, inter alia stating that the revenue seeking to treat the payments made by the petitioner pursuant to the judgment of the Supreme Court in common cause as payments towards penalties, whereas according to the petitioners, these were payments, these were compensation amounts that had been paid. Paragraph, the court does not wish to express any view on these submissions at this stage. Paragraph, Mr. Chetan Sharma, learned senior counsel appearing for the petitioner, states that the petitioner is filing an additional note of written submissions or what?
That's right.
It should be
encompassing the reply to what they have just filed,
which may be placed on record after advance copies are given to Mr. Chimanka, learned counsel for the review. Interim order to continue. List for final hearing. We'll have it in July then.
But before the rains, in the heat of summer, so that it's not washed off.
No, here we are closed from.
But could I make a vain and valiant, though this is
The Odisha heat. You want to enjoy that?
Only to plead, 14th, 21st, or 28th of March. I'll not take more than 7 to 10 minutes, that's all. This matter has been on, and the revenue too, would be anxious to say that this interim order goes.
We'll have it on 6th April.
Very well.
All right, 6th April.
6th April.
Quickly list item 35.
35, my lord. 35, my lords. Yesterday, my mother-in-law was expert. I am unable to go through the brief. That I prayed it come next week.
All right. At the request of counsel, the petitioner list on 27th April.
Quickly list item 36.
May I please your lordship? Milord, I'm so sorry, Milord.
Your lordship.
I beg your lordship's leave, Milord.
Sorry. Yes, one would Miss Patnaik. Yes, Mr. Sharma.
Milord, only if it could be, if your lordships could be kind enough, 4th of April, not instead of 6th.
All right, 4th.
I'm so grateful. So deeply obliged. I'm so deeply grateful.
Yes.
Lord, may I please your lordship? I'm for the petitioner, my lord. In this case, last occasion I have submitted a NGT judgment. Lordship, kindly have a glance to that NGT judgment. What is the stand of the government there? In this
we have somehow misplaced a file in the office, your lordship. We have to constitute a new file. Can it come up some other day, your lordship?
All right. Ms. Patnaik states that their file has had to be reconstructed and prays for an adjournment. That's on 6th April.
Obliged, your lordship.
All right.
Hearing item 37. 37 is covered by your lordship's order. In past, I am giving it. That return, if is not accompanied by the profit and loss account. Else, I have given the orders which have been passed.
All right. In view of the order dated 7th February 2022 in ITA 40 of 2007, bracket Commissioner of Income Tax versus Orissa Mining Corporation, that is involving the very same assessee for an earlier assessment year. The present appeal is dismissed.
Item 38.
Same. In view of the order passed today in 18 of 2012.
Both the cases same.
This appeal is dismissed.
Both the cases same.
Item 39.
I'm from the opposite party.
None appears for the appellant. Dismissed for non-possible. Chimanka for the revenue.
Item number 40.
My lord, item number 40. Your lordship may kindly, your lordship order dated 24/11/2021. Your lordship wanted whether how many posts are there to be filled up. And in the meantime, your lordship was pleased to advertise about 19 posts.
Mr. Udali,
Yes, well, I am passing on the instructions.
we given her a copy.
Well, here, your lordship, kindly.
Yes.
My lord, in view of the vacancy position, Your Lordship may allow my writ petition.
In view of the
No, but you have a right for revaluation of the marks is the question. That's your main prayer.
My lord, I have a right in view of the judgment of the.
He has prayed for re-evaluation of the marks.
My lord, yes, on the basis of the judgment of the Honorable Supreme Court, my case has been admitted, wherein the Honorable Supreme Court has held that the power under 226.
No, power is there. In your case, have you made out a case for evaluation is a question.
Yes, my lord. I have made out a case. I will show you, Lordship. Lordship, I think on the last occasion, I have shown you, Lordship, how I am entitled to get. Right now, I have my secured 45.5 marks. And your Lordship was in the last occasion, your Lordship may kindly turn to page 41.
Yes.
Page 41, the question was, my lord. Question was, what is the prescribed procedure for trial of accused under the prevention of, my lord, I'm sorry, section 18, can anticipatory bail under section 438 of the Code of Criminal Procedure be granted to a person accused of commission of offense under Schedule Caste and Schedule Tribe Act? My answer was, section 18 of the SC and ST Act deals debar a court to grant anticipatory bail so far as 438 application is concerned. An accused had no right to be admitted to pre-arrest bail under section so and so, and 2016 one decision has also I have stated here.
No, this is not one 3-line answer, right? This is not like a yes/no answer. So you can't insist that it can't be 0.5; it has to be 1.
No, my lord. The entire, my lord, 6 marks are provided for the answer, and I have correctly answered the question. If I have correctly answered the question, only 0.5 marks have been given. Five marks. And question number 2 also, my lord, and the same line. Question is, what is the prescribed procedure for trial of an accused under the Prevention of Corruption Act, so and so? My answer was, section 5 of the Prevention of Corruption Act lays down that the trial of an accused under the Act, the trial must follow the warrant procedure such as 238 to 248 of CRPC.
I think you've not had time. So you're just writing it like one objective type. That's the whole problem.
My lord?
It's a 6-mark question, madam.
My lord, is 5 marks question.
Whatever. This is too short
I am
for a
entitled
5-mark
to,
question.
if I have correctly answered, at
It's
least.
not about correct, wrong. Is it adequate as an answer? And the evaluator has to decide that.
My lord, my submission, may I pray your lordship may keep it to some other day. This is the, I will. That will be better.
I know this is the only point left now.
Yes.
All right. Mr. Mudali has handed over the copy of the communication dated 22nd December 2021. The copy which has been handed over to counsel the petitioner, which talks of there being 2 vacancies in the promotion quota and 2 plus 1 vacancy. This one is what in the direct recruitment quota?
One vacancy is compulsory retirement.
From which quota? That's not clear. But there are 3 vacancies, you see. Counsel for the petitioner wants to argue the case on merits at her request list on 7th April.
17th of March,
7th April.
7th April, Oblastment.
On Passover. Pastor matter item number 2.
The demand is more than 5 crores and the question of law arises at page 8, my lord. Whether the learned IT is justified in passing the assessment order under section 143 and considering upon the revision order made under section 263, especially when there is nothing in the statute to hold that the assessment order should not only be passed, but also to be served to the assessee on for the date prescribed under section 153(1). Lord, I am going to the tribunal order, page 55.
It should be served, sir. If it is not served, how will you know you passed such an order?
Yeah. But in the ITA 127 filed with the SSC for the assessment year are dismissed. But in the case one is allowed. So for against the allowed, we have filed this ITA for your lordship.
It's okay. I think whether served or not depends on the facts of each case. Sir, you're filing appeals like this for 3 ITA numbers, 1 appeal you're filing.
Yes.
Yes, Mini?
No, we have filed 3 appeals.
No. You're filing 1 appeal for 3 matters.
No. It is written here, but we have filed 3 appeals, 1 another matter, another 3 files.
What happened in those matters?
The one is 5, 2 days on the list.
What has happened in that 5?
It is allowed by 5. I was.
No, it was listed today.
Yes.
5 of 2013 is not listed today.
ITA 5 of 20, item number 13.
1-3?
Yes.
What happened in that? Dismissed. All right. In view of the dismissal of ITA 5 of 2013, the present appeal is also dismissed by a separate order today. All right.